The Senate Judiciary Committee will come to order. The clerk will call the roll.
Mr. Chair, you have a quorum.
Okay. The first bill, Senator DeSteph is here. It's Senate Bill 418. What would you like to do?
Mr. Chairman, members of the committee. Let's try this. Here we go. Now we're on. Mr. Chairman, member of the committee. So Senate Bill 418, what that does is military retirees get what's called military retainer pay when we retire. Federal law prohibits the division of MRP in divorce proceedings until an act allowed it. By the way, this is a by request bill. I believe we've got the gentleman or the head of the group that wanted us to carry this bill online to testify
Senator Steff,
today.
can I ask you, Mr. Chair?
Yeah.
Can I?
Mr. Chairman.
There are 50 states, the union each has its own divorce law. Are there any of the other 49 states that treat MRP the way you want it treated in this bill?
I do not believe so, Mr.
So
Chairman.
we would stand out as 1 in 50 if we passed
I
this.
believe that's the case, Mr. Chairman, but let's, I believe the gentleman who's going to be online on this is the subject matter expert.
Okay.
Okay, let's, the bill is the purpose of dividing marital property, military retainer pay should be classified as separate property. And we'd be the only state that does that, right?
Yeah, Mr. Chairman, that's correct.
Okay, if you'd like him to speak briefly.
I'd like to, actually, to be honest, I'd like to turn it over to the gentleman who wanted us to carry this bill. I know he's online and excited about testifying.
Okay, we'll give you 2 minutes.
I'd give him 3, sir, and I'll give him all
Okay.
my time.
All right, give you 3 minutes. Senate Bill 418 of Senator DeSteph. What's his name?
Senator DeSteph, could I get the name?
Yeah, he's a retired colonel. Should be online right now.
He's a retired colonel. Which branch?
Is it Lawrence?
He was
Dale?
Air Force, so.
Air Force. Okay, retired Air Force colonel wants to speak about it.
Could they raise their hand possibly? Because
I believe so.
okay, got it. Mr. Chairman, Senator DeSteph, Lawrence Dale is on the Zoom right now.
Okay, perfect.
Okay, go ahead.
Well, I was actually going to speak against the bill. I believe he had an expert, so I could talk now or defer to him and then come on after that.
Okay, you had a colonel in the Air Force that wants the bill? No?
Let me phone a friend and get the gentleman's name real quick. Philip Leinert. Philip Leinert. Thanks. Got him? Perfect.
Colonel Liner, are you there?
Colonel Liner?
Colonel Leinert, would you please unmute?
Yes, can you hear me?
Yes, go ahead. Colonel, go ahead.
Okay, my name is Philip Leinert. I'm actually a retired captain from the U.S. Air Force. I live in Virginia Beach. That's where I am now.
Go ahead. Why do you want Senate Bill 418? The Division of Marital Property.
Yes, because this situation with MRP being awarded to many ex-spouses is just wrong in many ways. It's wrong. It's causing a lot of problems. It's abusive. So I'll spend a couple minutes, if I may, talking about that.
Go ahead.
It's, it started because of the U.S. FSPA Act of 1982, which violates states' rights in divorce proceedings. Divorce proceedings are always a states' rights matter, but a law by the Congress tried to change that, which should have never happened. What they did in 82 violates a 1981 U.S. Supreme Court decision. That decision by the U.S. Supreme Court states that military retirement system confers no entitlement to retired pay upon the retired member's spouse and does not involve even a limited community property concept. This MRP, military retainer pay should not be thought of as property. It's income. Income is not subject to division like this, like property is. Furthermore, the Supreme Court said that doing so would threaten grave harm to federal interests. They also went on to say that MRP is property of the military member. Also, that federal law includes the state court dividing MRP pursuant to state community property laws. So like the senator said earlier, this would be, Virginia would be the first state to do this, to make this change, but it's wholly appropriate. And other states should have done this years ago and should follow us. Virginia should be happy to be the leader in this matter. Also, that 1982 act by Congress violates the IRS tax code. The tax code says that MRP is a wage or an income. Again, it's not property, it's an income. The act also violates the DoD policy, the Department of Defense policy. MRP is reduced pay for reduced service. It's not something to be conferred to ex-spouses. It's been given by Congress, by the US Congress when it was initiated back in the 1800s, to the retired military members only. Also, this act does not, in a worst case scenario, believe it or not, an ex-spouse can seek 100% of MRP after 1 day of marriage. This is not the least bit likely, but it actually could happen given the bad wording of the US FSPA. Also, that created an army of lawyers representing ex-spouses who are taking money from the troops and getting a percent of money awarded to the spouses as well. In summary, all US courts agree that MRP, military retainer pay, is not an annuity or a pension or a payment for fully retiring from the armed forces. Those retired from active service are still in the military service essentially, and that they are subject to recall and subject to the Uniform Code of Military Justice.
Mr. Chair, could I ask a question?
Thank you very much.
Captain Leonard, I think you said that a 1982 act of Congress violated a Supreme Court holding from 1981. Do you know if anybody's ever legally challenged that congressional act of 1982?
At least one person has testified to the US Congress that that's what happened.
Has anybody filed suit to try to challenge that law as being unconstitutional?
Not that I know of.
Okay, thank you.
Thank you. Next, we have another speaker. There's somebody who wants to speak against the bill.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, we do have one person.
Okay. Can you keep it to 2 minutes?
Lawrence Dale, would you please unmute and begin your testimony?
Yes, Mr. Chairman, members of the committee, I'm Lawrence Deal. I've practiced family law for 47 years. I've done probably over 100 military division retirement cases, have even litigated those frequently. And in all due respect to the other speaker, that's not the law at all. We've divided military retirements to recognize the former spouse's contributions and equitable distribution. Our factors look at that. There's a maximum of 50% of the marital share under 2107.3G. So his statement that they get 100% is just legally wrong. I don't know other states, but I know in Virginia we have a 50% cap of what's called the marital share. 10 U.S. Code section 1408 says that the courts can divide payment of retired or retainer pay in compliance with court orders. And section 10 U.S.C. 1408A7 defines retired pay as including retainer pay. So if we were to enact this amendment, we'd be basically causing economic hardship to the former spouses who've contributed to that career. And we all know that's a lot of sacrifice through career giving up, changing locations due to duty stations, all of the factors that courts look at when we divide up military retirements. We have a large military constituent here in Virginia, and this would be detrimental to those spouses that have made those contributions.
Chair,
and we've been doing it for we've done it for 40 years.
Thank you very much. Okay, Senator Deed, you have a motion?
Motion is passed by indefinitely.
Motion has been made and seconded to pass the bill by indefinitely. All in favor of the motion, vote aye. All opposed, no.
Mr. Chair, members of the committee, thank you so very much. Have a wonderful day.
Thank you.
Ayes 8, noes 3.
Yeah, no, Senator Stewart has somebody who would like to speak on his bill.
Mr. Chairman, thank you, and I need to go to another committee, but I appreciate your letting me do this. Senate Bill 618, if the committee will recall, we passed a law a couple of years ago, I think it was Senator Lucas's bill, against paramilitary activity. We then had an exception for honor guards and color guards and the like who were either training or participating in an event. I think that bill passed unanimously last year in the Senate, and the House, for some reason, killed it. It is my understanding this is the identical bill that passed the House. Charles can correct me if I'm wrong. And there is one amendment.
Okay, we got an amendment?
Report that.
Yes, Mr. Chair. It's basically a technical amendment. On line 27, after service organization, insert unless such member engages in such activity with malicious intent. And now if the committee adopts it, it would be identical to the House version.
Okay, is there a motion?
So moved.
It's moved and seconded that the amendment be adopted. All in favor say aye.
Aye.
All opposed, no. And I understand you have a speaker?
Mr. Chairman, I do. I've got a live retired colonel from the Marine Corps, John Klickner, who can speak to this briefly.
Number 5, sir.
Chairman, I'm John Klickner, Chairman of the Legislative Committee of the Joint Leadership Council. We respect Richard Stewart's service as a Marine, and we thank him for carrying this bill, and we ask you to report it. Thank you, sir.
Yeah, thank you, Maureen, appreciate it. Anybody have want to say anything, one way or the other?
I would just like to ask the patron a question. Are there examples of people color guards that have been threatened with prosecution around the state? They've been threatened with prosecution of this classified felony engaging in paramilitary activity?
Mr. Chairman, I have no idea. We just want to make sure they aren't.
Okay. Any further discussion? Anybody else would like to speak on the bill, one way or the other? Is there a motion? Been moved and seconded to report the bill as amended. All in favor of reporting Senate Bill 618, vote aye. All opposed, no.
Ayes 14, no 0.
You didn't vote? Okay, 14-0, the bill passes. Okay, the next bill, Senator Pillion is here, selling or possessing switchblades. Senator Pillion, Senate Bill.
Yeah, that doesn't go with me, does it?
758.
Well, good afternoon, co-chairs and members of the committee. I know that each of you has been briefed on this bill, and I'll keep my testimony short and to the point. If you have any questions, I've got my trusty legal counsel, Mr. Helm, here in case I need to, or Bill Stanley, in case I need to phone a friend. This bill is very straightforward. It simply allows a person to have or transfer a switchblade, the modern term for which is an automatic knife in Virginia. That's it. This is not something I normally carry. In fact, the last time I thought about a switchblade was when I watched West Side Story, the original version of West Side Story, when I was in high school. However, I introduced this bill on behalf of a family-owned and operated distributor of cutlery, knives, and other accessories in my district. This business, Blue Ridge Knives, located in Smith County, has grown over the years from a business that could fit on the top of a card table into one of the largest distributors in the world. They have a warehouse that's 266,000 square feet, and it's one of the cleanest and well-organized facilities that you can imagine. I'd encourage you each to come on down to Southwest Virginia and take a tour. It's really quite impressive. They're a significant employer in my district, and if the bill passes, we expect them to grow even more.
So
However,
this is economic development?
it's a jobs bill, Mr. Chairman. However, one thing that Blue Ridge can't do is distribute a switchblade in Virginia, and that's because Virginia is one of the 6 states that doesn't allow possession of one. This bill doesn't allow the possession of one. This bill doesn't change concealed carry provisions or anything like that. It simply removes the term switchblade from the list of items that you're not supposed to possess in Virginia. A switchblade, in my opinion, doesn't belong on the same list with ballistic knives, throwing stars, or oriental darts. They are not projectile weapons and are not much different than a folding pocket knife. A switchblade is mainly a tool used by sportsmen and women, first responders, when one of their hands is occupied and they're doing something else and they need to cut a seatbelt away, or from workers like electricians or roofers who may benefit from a tool with a one-handed opening, such as opening a box or cutting a shingle. Before I wrap up, let me also make the point that switchblade knives are rarely used in crimes. Even common folding knives are rarely used in crimes. The most common knife used in a crime is by far the kitchen knife, which is universally found in every household. Virginia is one of the 6 states that doesn't allow possession of switchblades, and I ask that we update our 1950 statute and delete this term from this particular section of the code. Thank you, Mr. Chairman.
Okay, any questions of the patron?
Mr. Chair.
Yeah, Senator Morsi.
Senator, I know somebody was a little bit laughing about a jobs bill, but how many jobs does this affect in your jurisdiction?
So currently thank you, Mr. Chairman, Senator Morsi. Currently, they employ about 66, 67 good high-paying jobs, and they expect to add 15 to 20 more jobs.
All right, thank you.
Okay, thank you. Any other questions of the patron? Anybody who'd like to speak for the bill?
For those
Anybody?
attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised.
Okay, you got it.
Oh, sure.
Philip Van Cleve, VCDL. Yeah, we support the bill. And it's also handy for people that have physical issues, like maybe only one arm or have very weak hands. Thank you.
Okay. Anybody else speak in favor on Zoom or anything else? Okay, we got somebody speak against it, I believe, right? Yeah.
Mr. Chairman, members of the committee, Andrew Goddard, Virginia Center for Public Safety. We have a couple of problems with this bill. The term switchblade knife covers a tremendous number of different types of knife, many of which are quite innocuous. But it also covers knives which are designed primarily as thrusting weapons with narrow, thin, double-sided pointed blades. Those have no utility for cutting shingles, whereas there are many, many knives which have a design which can be used by one hand. One of them is named after a member of this committee, Mr. Stanley, Senator Stanley here, the Stanley knife. It's an excellent knife for cutting shingles. So the second problem with this is... Cuts through the crap.
Go ahead.
Thank you. Very apropos. The second thing is that this legislation makes no effort to put a minimum age limit on keeping these, either purchasing or carrying these weapons. Now, I don't think we want our school children to be able to spend their pocket money on buying a stiletto or some knife that has only got a utility as a dangerous and offensive
Mr.
weapon.
Chair. Yeah,
I have a question for Andrew.
Senator
Andrew,
Peterson.
Sir.
and I listened to your comments, but you can go out and legally purchase a 30-06, which is a high-powered rifle that could kill somebody from over a quarter mile. And you can go hunting with your child and they can use that weapon. So I understand what you're saying, but it's not like you can't go out and buy a lethal weapon legally. What's unique about this one?
There's nothing unique about it.
Okay.
Lethal weapons in general are something that we should be monitoring very carefully.
I agree with that. And this,
it's not like you're going to be there when your child is hunting. You're going to be there when they're hunting.
right.
But you're not necessarily going to be there if they put one of those in their school bag.
Okay, but this is an outright prohibition. I mean, this is not like a concealed carry law. This is an outright prohibition, correct?
Well, you could change the bill to make it a concealed carry.
Well, it's already in the concealed carry statute. That's
Well,
my point.
you could put it in with an age limit.
Senator Sasslaw.
I was aware, somewhat aware about that being banned, but I got to tell you, I grew up in Washington, D.C. in the 40s and 50s, and almost every school kid had a switchblade knife, and you used it, you play mumbly peg, throw it to stick in trees. I don't ever remember anybody being stabbed by a pocket switchblade knife.
Okay.
I mean, I just don't see.
Is that a question?
I don't see the big, I don't see the big deal.
Okay. Anybody else have any questions? Anybody else want to speak, one way or the other?
How do you play mumble?
Is there,
I'll explain.
Is there a motion?
I'll explain.
It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no.
Stanley.
Stewart.
Ayes 13, no 0.
Thank you, Mr.
Okay,
Chairman.
13-0, the motion is carried.
Mr. Chair, I think we can, I've got Senator Obenshain's bills. I understand some people are here on those bills. They're going to go by for the day. There's 229 and 554. He's not here today. And my understanding is all the other patrons, except the ones that are on this committee, are on general law, are in general laws.
Senator Mason, yeah. Senator Mason, why don't you present your bill?
Thank you, Mr. Chairman.
Senate 688.
Senate Bill 688. So we've discussed a couple of bills along this line earlier this year. This is the beginning of an effort to see if we can set up a civil direction for people that are having mental health crisis and they're not criminal courts. Excuse me. What we already send when a psychiatric evaluation's done, we already send them into DBHDS de-identified so you can evaluate the evaluators. What we're trying to do is have that information sent to DBHDS so you can say, Monty Mason, trespassing, Eastern State. Monty Mason, petty larceny, mandatory outpatient treatment. Right now, we only get the information that goes to the state hospitals, and we're trying to drive more outpatient treatment. So this would be a comprehensive, a better evaluation of us being able to identify the data. There's a secure link. They already send these things. It's securely done. So this is just a step to start aggregating some information and compiling it so if we can move down a civil path in the future. Unfortunately, Mr. Chairman, DBHDS has chosen to suggest they might need an entirely new computer system to do this. I suggested one FTE, so we're a little off if and when we get up to the finance team, but that's a bill, Mr. Chairman.
Okay.
And I'm sorry, it's between lines, what we're asking for, between lines 54 and 61.
Okay. Is there any questions of the patron? Is there amendment?
No, Mr. Chair, but the bill does need to go to finance.
Right, and I put an I requested an FTE to gather the information. They think they need a $750,000 computer system, so.
Okay. Is there any further questions? Anybody want to speak for or against the bill?
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now.
No.
Mr. Chairman, there are no hands raised.
Okay, Senator McDougal, you have a question?
So we need the name, and so we're getting, what information we're doing?
So right now, what we do is just de-identify. We take your name and your personal information out, and we send the evaluation. We want to retain that, so if we have a next evaluation or if we have more information on you, we can start to determine how many times did you touch the system? What did we do? Were we able to move you to outpatient treatment? Did you go to Eastern State every time? Were you stuck in jail multiple? We're just trying to understand disposition of the many interactions, which we unfortunately call some folks frequent flyers in the courts, that we're trying to figure out how we help them, how we get them out of the cycle that is the court. And that's why we're trying to work to go down a civil path, but we need to gather a great deal of data and information before we start heading down what is going to be a serious rewrite, and probably need somebody with some legal chops beyond Mason to handle when and if we ever get to that point.
Okay. Any further questions?
Mr. Chairman,
Is there a motion?
my only other question is, this is in the competency section, so is this only if somebody's been found not competent by the court, or is this for every evaluation regardless of whether you've been found competent or not?
Every competency evaluation, yes, sir.
So, Mr. Chairman, so even if you were found to be competent, we're still sending this report?
Because they already, Mr. Chairman, Senator McDougal, yes, sir, because they already do it to evaluate the evaluators, of which we have scarce few, and you've seen that bill trying to raise their fees to try to attract more people to do it. So, yes, sir, Mr. Chairman, Senator McDougal.
Okay. Any further questions? All right, is there a motion? It's been moved and seconded that the bill be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no. Motion.
That's 13-0.
13-0.
Thank you, Mr. Chairman, members of the committee.
Reported and re-referred. There are a couple of bills that I've been told that I would like to carry over. Senator Kagan's not here, but Senate Bill 702. You've been told, okay. Without objection, I guess we need to report. All right. Senate Bill 702 will carry over till next year. All in favor, vote aye. All opposed, no.
Senator Saswell.
Okay.
Ayes 13, no zero.
And similarly, Senator Marsden has a bill 770 to be continued till next year. Okay, it's been moved and seconded that the bill 770 of Senator Marsden, places of confinement for juveniles, be carried over to next year. All in favor of the motion, vote aye. All opposed, no.
Ayes 13, no zero.
Okay. 412. Senator Morsi, want to deal?
Senator Morsi, I think, has 412 and wants to carry over the year. Is that correct? That's correct. Okay, I move we carry that over.
Senate Bill 412 of Senator Morsi, termination of parental rights, be carried over for the year. All in, is there a motion made and seconded? All in favor of the motion, vote aye. All opposed, no. Okay.
And then my bill 713 will carry over the year.
713 to be carried over for the year. Been moved and seconded that 713 be carried over for the year. All in favor of the motion, vote aye. All opposed, no.
Ayes 13, no zero.
Okay. Is there anybody who's not here on the committee? Guess we'll go back to the committee. Yeah, Senator Morsi.
113.
Yeah, 113. Senator Morsi, having to do with custody and visitation, grandparents' rights, mediation.
Mr. Chair, as I remember, we had a little discussion. We have had a fairly lengthy discussion of this several weeks ago, a couple weeks ago. Is that correct?
That's correct, Senator. Mr. Chair, Senator Deeds, you had a concern on line 21 about the situation where it would require that every judge refer the grandparents' custody case to mediation, and this amendment that I'm about to propose addresses that concern. And so I would ask to move the amendment that's may have been passed out already on line 21, after section 20-124.4, insert the words, comma, unless good cause is shown by one of the parties not to refer such matter.
So the whole idea behind this amendment is there'd be a presumption in favor of mediation. Is that what it amounts to? Steve, is that?
Okay, I'm sorry.
Or Kristen or somebody, is that what it amounts to, a presumption?
Yes, Mr. Chairman, in cases where a grandparent is the petitioner, there would be a presumption that the court would send the case to mediation unless one of the parties showed for good cause that it shouldn't be referred.
Okay. Any questions? Okay, Senator Morsi.
We covered this at length last time, and this measure would not be in contravention of Troxel, and unless somebody thinks otherwise, I think this amendment addresses Senator Deeds' concern.
Is there a motion to adopt the amendment? It's been moved and seconded that the amendment be adopted to Senate Bill 113. All in favor say aye. Aye. All opposed, no. Do you have anybody who wants to speak in favor or against?
You had people last time that spoke on this bill.
There was.
We need to.
I think, come on, I think we've already had people.
Yeah, I think so too.
The lady behind me was here last time, but she didn't speak.
Okay.
So
Yeah, she
I'd ask that you.
Yeah, okay.
2 minutes.
I was here last time, and I did speak at length, so I'll spare you all the details that I told you last time.
Can you do it in a minute, 1 minute?
Okay. Last week, of course, I spoke in regards to obtaining grandparents' rights with my grandchildren and for other people's grandchildren. And I believe strongly that if mediation had been required at the beginning of all the turmoil that went on with the situation with not just my case, but many cases, excuse me, that there may be some consensus that can come between the parties. As it was in my situation, my daughter was offered mediation. I wanted it desperately. She would not come. There was nothing to require her to come. If she had come and spoke before a social worker, they had no authority to do anything, whereas a judge does have authority to enforce this. I think it's imperative something be done to this, because as it stands right now, anybody can say yay or nay, and they don't have to follow any judge's orders.
Right.
And a judge would make all the difference in the world if it comes from him.
Okay, thank you very much. Anybody else that didn't speak last time would like to speak?
Yes, of course.
Senator Morsi?
Yep, I want to correct myself. I said a few moments ago that she did not speak last time. She did, and I think you recall the circumstances I stated about how she'd been so involved in the raising of the children for a lengthy period of time. So if you believe that that amendment assuages Senator Deed's concern, I'd ask that the bill be reported.
Okay, the bill, motion, and we hear somebody wants to stand up.
There may be people that want to speak in opposition.
Yeah, okay, go ahead. Did you speak last time? I don't recall. Okay.
Good afternoon. I'm Kim Ramsey. I practice family law here in Richmond, and I'm actually here today on behalf of the Virginia Family Law Coalition. And we are opposed to this bill. The main reason is well, there are a couple reasons, but one is it's not necessary. The code already provides for the court to order mediation in any case that they think it is appropriate. The problems with this is you're taking one subsection of parties who are interested parties under the code, and you're singling those out, the grandparents, and putting them in a different position from parents or any other interested parties. Also, something I thought was strange, although probably not the one of the other issues we had, is it actually then later, in some way, in a way, penalizes the grandparents by asking them to pay a fee that if it's any other party that's ordered a mediation, that fee is paid by the Commonwealth. So it's really not needed. 20-124 takes care of this, and it can be ordered by the court. So it's just not necessary to single out grandparents, and they shouldn't be singled out as a group when they fall under a category that can receive mediation. So the Family Law Coalition is opposed to this. And there's just not, the main reason being, and I know it's important often in these hearings, that there's not really a need for a change. It's already dealt with.
Okay, anybody else want to speak?
Mr. Chairman, we do have two people online who would like to, three people now who would like to speak on behalf of the
Okay,
bill.
30 seconds apiece.
Pamela Price, would you please unmute and begin your testimony? Pamela Price, would you please unmute and begin your testimony, please? Pamela Price, would you please?
Yes.
Would you
May I
please?
speak, please?
Yes, you can.
I spoke briefly last time, but I was not able to get my 2 minutes. If I could have that, I sure would be appreciative.
Go ahead. I'll give you 1 minute. Can you go ahead? 1 minute.
Okay, well, I cared for my grandchildren since their births, but to add to their trauma after their father died, we were inexplicably taken away from them. And we've been petitioning Virginia courts for visitation for 4.5 years. We want them to know Andy's family has not stopped loving them. I believe passage of SB 113 would be another positive step in considering the best interests of children in grandparent visitation cases like mine. We have offered mediation through the court system at our expense, but it has not been accepted. We also petitioned the court for a guardian ad litem. We've requested evaluations, all at our expense without success. We're fully willing to work through any roadblocks to visitation, but we haven't been given that chance.
So
Experts.
You're in favor of the bill?
Yes, I am.
Okay, all right. Is there somebody else want to speak in favor or against?
Lawrence Dale, would you please unmute?
Yes, Mr. Chairman and members of the committee, my main concern is that we're transferring to mediators, many of which are not attorneys, very complex legal issues. That's a threshold finding in order to even give the point where they would get into negotiations about how the visitation might be set up. We have Williams and the Griffin cases that have set a threshold of finding a actual harm to that child under the Troxel case. And if we send all these legal standards to the mediator to have to argue about, I think that's beyond what they're capable of doing. This should be a judge decision first. If there was mediation after the judge says, I find that there is they've met that standard of proof, which is a high standard, then they could transfer the mediation for those effectuation of that order. But to send it before that's even been decided is premature. These are very complex legal issues. I've litigated them in the Court of Appeals, and these really shouldn't be the topic of a mediator. Thank you.
Mr. Speaker, why in the world are we having so many issues dealing with grandparents' rights? I see them occasionally too. Anyway, Senator.
You're asking?
Yeah.
You were asking me?
Yes.
Well, I mean, obviously, we have a Troxel case, which has kind of given us the standards that we have to meet because of the rights of parents to have the right to raise their children. That's the Fifth Amendment and 14th Amendment rights that were in Troxel. And so a lot of times there's animosity between the parents and the grandparents, and that's just the way life is. We have to meet that standard. In the best of all worlds, they'd all get along. I got that. But it's still the parental right is the primary concern legally. And I'm not just speaking academics. I'm talking about the level of proof that has to be found by a trial court. And it's a high standard. It usually requires experts. And those experts wouldn't be available to mediators to know whether that standard has been met. Again, I just have a problem transferring those to a mediator.
Okay. Anybody else want to speak?
Jennifer Newman, would you please unmute? Jennifer Newman, would you please unmute?
Jennifer Newman.
Good afternoon, Mr. Chair. This is Jennifer Newman. I am an attorney here with the Office of Executive Secretary. We spoke briefly the last time, but wanted to make clear that even with the amendment, the court has a concern regarding the implementation and the conflict that arises in the courts with the code. 20-124.4 is actually a referral to a dispute resolution orientation session. And then mediation is determined, number one, whether or not the parties themselves want to attend and whether or not the mediator believes it's appropriate. Further, I would just point out to the committee that the fee that is listed in the end of the bill of $100 is less than what the mediators are currently making for the cases that are being sent to them through the current statutory framework of dispute resolution orientation.
Okay, thank you. Any further questions of anybody? Okay, is there a motion?
Mr. Chair, since I raised the objection last time, I appreciate your effort, but the court has the ability right now, when it looks at the best interest of the child and determining that, to determine whether mediation is in the best interest of the child, and can already order mediation. And this attempts to create a presumption on the part of mediation on the part of grandparents, which, as has been pointed out in a couple of places, penalizes them later on by making them pay a fee, which isn't enough, as the woman from the Office of the Executive Secretary just testified. I'd make a motion to PBI the bill.
Let me respond to Senator Deeds, if I may, Mr. Chairman.
Morsi.
I understand your point, Senator Deeds. This, first of all, even though mediation is allowed, this is a narrow, I would say, taking an X-Acto knife to the situation that allows a special group of population of people, the grandparents, some of whom, in the case of like Mrs. Holloman, who raised the children, who spent 6 days a week, 8 hours a day, and then for really no reason at all, perhaps there was some mental health, she alluded to that, issues, cuts it off. We all know that at the end of the day, the parent's determination is going to be final. But allowing this mediation, that may, in fact, allow that child to see the worthiness and the nobleness of having grandparent see child. Yes, I agree that it selects grandparents, but I can't think of no other group that would be more appropriate to single out.
And I agree with that, but in my own practice, most of the time, I think courts are in a better position than the General Assembly to determine on a case-by-case basis whether mediation is justified, whether it ought to occur.
Okay. All right.
Motion to PBR.
Moved
I would
and
second it.
seconded to pass it by indefinitely. All right. All in favor of the motion, vote aye. All opposed, no. To pass by the bill indefinitely, Senate Bill 113.
Stanley?
Ayes 9, noes 4.
Okay, 9-4, the bill is passed by indefinitely. Okay, you got two more, Senator Morsi?
Yes.
Senate Bill 639.
Certainly. Mr. Chair, members of the committee, we took up 639 last time, and the issue involves not having a show cause hearing for an individual who had overdosed. Remember, we passed a law last year that stated if you are the report
I think we took some testimony on this bill too, right?
We did.
This bill just expands it to those who would face a probation violation otherwise. Is that
Right.
correct?
Correct. What it did is it said you can't show cause the person, and the issue came up regarding whether it's a technical violation, Mr. Benjamin, or it's a special condition. And the issue arose as to whether or not you can get any jail time for the technical violation. Upon further research, it shows that under 19.2, 306.1C, for a technical violation, no jail time, but for a second technical violation, up to 14 days, and for a third technical violation, you can give the full sentence. Additionally, if it's a special condition imposed by the judge, you can get the full sentence. A special condition is distinguished from a technical violation. So if the judge says, as a special condition, you cannot use drugs,
Okay.
then that would not be a technical
I move the
violation.
report.
Okay, is any further, all right, any questions of the patron? Been moved to report the bill and seconded. All in favor of the motion to report Senate Bill 639, vote aye. All opposed, no.
Mr. Chairman,
Yeah, Steve Benjamin? Huh?
I think the intent of the bill is laudable.
Strike the board.
Yeah, sorry. I think the intent of the bill is laudable.
Stop there, just.
Yes, okay.
And what else?
Can I add but?
Is there a but? Is there a but?
Look, I'm not going to go on at length, but a lot of work was done last year on the code section that Senator Morrissey references to strike a balance, to ensure that people are encouraged to seek help for an overdose without fear of sanction. And laudably, this bill seeks to extend that protection. The concern that I have is that in the process, it upsets the balance that was struck by the work the General Assembly did last year in permitting somebody to be returned to court and ordered into drug evaluation or drug treatment where necessary to save their life, quite frankly. And so, in a nutshell, that's my concern. A laudable intention may interfere with excellent work that was done last year.
So you're saying we don't need the bill? Is that what you're saying?
Well,
Thank you, Steve. I
afraid of
can't
upsetting
help but
people.
say this, Mr. Chairman. Growing up, one of the children in my family would say to my mom, I don't want to tell on Bill, but, and she would say, well, then don't. So along with Senator Peterson said, Mr. Benjamin, let me just respond very briefly. Yes, we want them to get help, but what we don't want to do is to allow for a incarceration. Often I have cases up to 5 years for a using drugs, and that's all I'm trying to get at. And that's why I think at the very least show cause should be in there. My legislation says show cause probation, revocation, or parole violation.
I'm only here to help.
I know, I realize that.
Motion on the floor, Mr. Chair.
There's a motion been made and seconded to report Senate Bill 639.
And Mr. Chair?
Yeah, Senator Peterson.
As much as I want to support my brother Morrissey, is this just the show cause language, or is this all three categories?
There was some question last time, did we take out the other two?
Right, because I thought we had taken out I have a problem with if someone is, on probation and they're not supposed to be using drugs and they obviously are overdosing, then, you got a probation violation. I don't know how else to
Let me do this,
interpret that.
Senator Peterson.
Okay.
Mr. Chair. Amend, if it hasn't already been done, on line 14, no individual shall be subject to arrest, prosecution, or show cause, thereby deleting the words probation, revocation, or parole violation.
Okay, if that amendment's not been made out, yeah.
Okay, thanks.
All right, okay. Is there a motion to delete probation violation or?
Senator Morrissey made it,
Yeah,
Senator
okay.
Google seconded it.
Been moved and seconded for the motion, to the amendment to be made. All in favor, say aye. Aye. All opposed, no.
Now move to report.
Okay, all right. All in favor of the motion to report Senate Bill 639 as amended, vote aye. All opposed, no.
Ayes 13, no 0.
Okay, now Senate Bill 642, you want to do that, Senator?
Yes,
Dorsey?
sir.
Preliminary analysis of breath to determine alcoholic content. Failure to advise. We heard that last time, too.
Yes, sir, we did. Again, to address a point, there's an amendment. I have this. On line 38, after cause, strike the remainder of line 38 through trial on line 39. So after cause on line 38, strike the rest of that sentence.
Okay, is there a second? Is there a second to the motion? Okay. All in favor of the amendment, say aye. Aye. All opposed, no. Motion granted.
This is a real simple bill. Most people are familiar with the concept of a preliminary breath test that is offered at the scene. Do not think about a subsequent blood or breath test because this legislation doesn't address that. When an individual is stopped by the police for DUI, the police can give what's known as a preliminary breath test, and the law already says that the person, underline paragraph C, shall have the right to refuse. All this legislation does is say that the police officer must advise him of his right to take a preliminary breath test.
Question I have, is this a practical thing?
Do I think it's practical?
Okay, is any questions of the patron? Anybody want to speak in favor of the bill? Okay, here we go. Mr. Dix.
Mr. Chair, Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill. We appreciate Senator Morrissey bringing it forward. When the General Assembly enacted this statute that gave someone stopped and suspected of DUI certain rights with respect to the PBT, they didn't provide a remedy if an officer fails to do that. And so what a lot of our practitioners are finding is they're getting stopped and the officer is just saying, blow into this. They're not even advising them of all the statutory rights. This will now provide a remedy where one did not previously exist, and we hope it will be the pleasure of the body to pass the bill.
But this is merely a probable cause to take the...
Correct.
It's not admissible in court.
Correct, right. PBT can't be used for purposes of the conviction, but it can be used for purposes of probable cause.
Right.
The problem is that when officers are not advising them of the rights, there's no remedy.
What about the fact the officer will say, well, I'm taking you down anyway because you smell like, you smell like you've been drinking?
Well, if he has other grounds, then that's fine.
Yeah.
Right, yeah, exactly.
Okay, yeah, Senator Stanley?
Look, having represented thousands of people on this, the thing is when you pull someone over using your lights and your siren and you display your badge of authority, you're in a quasi-custodial interrogative position and posture. They should tell you at that moment, if they believe that there's a suspicion of drinking and driving, that the tests you're about to give, including the FSTs, field sobriety tests, because you're giving evidence against yourself in violation of your own Fifth Amendment rights. They should tell them back then. Because they don't know. And usually police officers are like, look, man, this magic box that's sitting in my trunk, If it comes up low, I'll let you go. How many times you hear that? Okay, come on, lady luck. And then, oh, too bad. Bye-bye. And you may have done well on the tests. But if you blow in that box, which has probably been in the heat or the cold, and it's not admissible for a certain reason because it's not that reliable, and you go get popped for jail, everything you did otherwise just goes right out the window because you consented to that preliminary breath test. This is a great bill. About time.
Okay, Senator Norman.
America.
Senator Norman.
Justice.
What's perplexing to me, and I know just a casual amount about this area of the law, and I would say a high percentage, not all, but a high percentage of law enforcement officers put you through the NHTSA field sobriety test. And at the conclusion of them, then they will offer you the PBT. So from a practical standpoint, you just exclude the PBT. But if you're arguing probable cause, then it's going to come down to the police officer's observations about their demeanor, the performance on the field sobriety test, and that's going to get you over the probable cause, issue. If we're going to go this far, if you really think that you're doing something that is significantly changing the law and protecting those that Senator Stanley may or may not be correct in saying they're in custodial interrogation on it, but why don't we put in there that the officer must advise the suspect that they don't have to take the field sobriety test?
Yeah.
I wouldn't object to that bill if it comes up next year, if you author it next year. But here's the difference, and I thank both the senators. The legislation already says in Section C that he shall have a right to refuse, this is line 23, the preliminary breath test. And I agree with Senator Stanley that the others, perhaps you should advise them you don't have to take it, but remember, the officer is going to see the behavior, the mannerisms of the defendant anyway. All this does, the language in lines 36 et sec, is to state what you've already said the law is, you don't have to take it. And remember, this only comes up when you're challenging probable cause. If the issue turns out that the person stumbled through field sobriety test and couldn't recite and was weaving back and forth, that's going to be sufficient for PC. This is solely limited to a preliminary breath test being used for probable cause if the officer did not advise the defendant.
Is there anybody speak against the bill? Okay, anybody? Yeah.
Mr. Chairman,
Steve?
I agree with everything that's been said about this fine bill.
Full stop.
But.
And suggestion to improve it, because what I have seen in body cam videos recently are officers who read a card so quickly that I can't understand what's being advised. And so to address that situation, you might want to insert on line 36 the word adequately, to adequately advise a person. Any other word might do, that's just what I came up with.
Okay, is there a motion to accept that motion? Is there a motion to, anybody moving that particular amendment?
I'll move it.
I'll second.
Is there a second? All in favor of that amendment, say aye.
Aye.
All opposed, no. Okay. The motion carries.
District court judge is going to figure that out.
So, Mr. Chair?
Yeah.
We've covered a lot. We've done 2 amendments. One, we now have to adequately advise, and at the end of line 38, we put a period after probable cause.
Okay. All right, it's been moved and seconded that the bill as amended be reported. All in favor, vote aye. All opposed, no.
Ayes 13, no zero.
13-0. Yeah, Senator Hanger, you're here? Since you're here, since you're not on the committee, we'll take you up.
Thank you, Mr. Chairman, members of the committee. I have Senate Bill 98 in front of you today. Mr. Chairman, members of the committee, Senate Bill 98 is a bill that will be familiar to you because I had it in front of you last year, and it deals with the issue of when someone refuses to sign their summons when they're detained, that you could inform them verbally of their commitment to appear, and it basically reduces the escalation that you see between officers and people that are pulled over when you get into the situation. We had a number of, it was generated initially by a police officer who suggested to me in Waynesboro, and actually last year you all reported this unanimously and it cleared the Senate unanimously. It got held up over on the House side, and Senator Mason was able to get a small piece of it through. But the bill that I had introduced was detained in courts of justice on the House side. I reintroduced it this year, and after I did, the new Attorney General's representatives had some concerns about it, so I was intending to carry it over, but we circulated it, and the staff at the Supreme Court basically suggested some amendments to cure it, which I liked and think it is in good shape now. And you all liked it last year, and I hope you'll like it again this year. Staff has that for distribution, and I would like for that to be adopted to substitute.
Okay. You got the amendments? Wherever they are.
And Mr. Chairman, I could explain the additions to the Supreme Court. Well, actually, I could read them to you. Okay. I'm not sure that would be an explanation, but staff may be better able to provide you the interpretation of what the Supreme Court suggested.
Charles, Kristen, you want to explain it?
So, Mr. Chair, the amendments to the substitute are basically lines 36 to 39. Again, on line 99, lines 161 to 164, lines 212 to 215, and lines 232 to 235. And basically, the amendments, what they do is, if someone fails to appear, there was no direction in the code what would happen if they failed to appear to the hearing in which they were given notice for. So for the first set of amendments on line, for section 2.2311, basically, if you fail to appear for a summons issued by the State Inspector General, it will be treated in the exact same manner as failing to appear if issued by another law enforcement officer. And that's provided for in 19.2128, which does make it a Class 1 misdemeanor to fail to appear for such summons. The additions on lines 161 to 164, 212 to 215, and 232 to 235 all deal with summonses issued by D4 investigators. And basically, the penalty there, if you fail to appear, is your license will be suspended and no new licensure shall be issued until the person appears for the hearing, which is similar to the provisions located in lines 124 to 127 for summonses issued under Title 28.2.
How many people are going to be losing their license because of this? Anybody have any ideas about that? Okay, Steve Benjamin?
Mr. Chair, I suppose if they showed up to the hearing, they would not lose their license, would be the answer.
But some people forget, I guess. But still, this is better than what? Arresting somebody?
Correct, that is the alternative. If they do not sign the summons or their promise to appear, then they would be taken to the magistrate, and that is the purpose of the bill.
Anybody want to speak for the bill?
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
Good afternoon, Mr. Chair. Sean Winata speaking on behalf of the ACLU of Virginia. We believe this is a valuable de-escalation technique, and we support the bill. Thank you.
All right. Next person.
Members of the committee, Maria Jankowski with the Indigent Defense Commission. It is a rare win-win for everyone.
That's good. Okay. Anybody else want to speak for, or anybody want to speak against the bill?
Mr. Chairman, there's one person in for the bill online.
Okay.
Ben Knotts, would you please unmute and begin your testimony? Ben Knotts, would you please unmute and begin your testimony? Ben Knotts, last call.
All right. Is there anybody speak, anybody else want to say anything? Is there a motion?
Mr. Chairman, Ben Knotts is with Americans for Prosperity. I'm really pleased to have their support on the bill.
Okay. All right, there's a motion to report as amended. Okay, and any discussion, all in favor of the motion to report the bill as amended, Senate Bill 591, vote aye. I'm sorry, 598.
98.
I'm sorry, 98, that's the wrong page. Yeah. Where are we?
Page 90, it's on the front, it's on the first bill, see?
Yeah, okay. Yes, yeah, Senate Bill 98, I'm sorry. All in favor of the bill as amended, vote aye for Senate Bill 98.
That's 13-0.
Okay, 13-0, okay.
Thank you, Mr. Chairman.
Senator Hanger, Senate Bill 591, cannabis.
Yes, in fact, Senator Searle, are you going to have a meeting of the criminal subcommittee?
He wanted this one, but the reality is, it's gonna have to go to finance from here.
We need.
Okay, that was the
get it out.
understanding. It wouldn't have to go to finance.
According to the notes we have,
You got a new note?
is that the finance committee's asked for this.
Okay. I will have to get a file to defend that one properly unless y'all are ready to pass it on out of here. It's a great bill.
Well, the concerns we had were whether the definitions mixed and matched too much with what we'd already done, and how it fit with the Department of Forensic Services with the way we can determine whether somebody's been using marijuana now.
And Mr. Chairman, the intent is, of course, it would restrict the use of products that appeal to children through gummies. It also would deals, and it was hashed out. I think Senator McDougal might have still had an amendment that he wanted to offer on it. I don't know whether, but it was, we had people from the forensic lab and from the Department of Social Services who all weighed in on it, and we think we've got it in good shape, except Senator Searle just wanted to make sure from the legal perspective that we had all our T's crossed and I's dotted. And that's, and I don't want to impose on y'all's time a whole lot, but this is an important bill, which with a lot of people supporting it, where we're basically providing an opportunity for products to get in the hands of children and some that aren't children that weren't suspecting that they were going to get a high on eating a bowl of cereal. So that's where it's at.
Okay.
And if we're going to meet again Monday morning for a few bills.
Okay.
So if you want to try to work it out with Senator Servell and come back in here Monday morning with
Come back Monday morning for Senate Bill 591.
Mr. Chair, the bill does need to go to finance, though.
See, when was that request made? I checked with the staff, and they said no before we let it go by last week.
It has to.
Well, it does. So the Sentencing Commission's issued a woodroom statement. So that's the $50,000 because we're expanding the definition of marijuana, which will pick up additional felonies perhaps. That's the genesis of why finance has requested it.
Okay. Okay, the only thing I do to maybe to get a ruling from finance that they don't want it, would that help?
Do what?
That would help, Mr. Chairman.
All right, I'll try that. Otherwise, do y'all want to take time this afternoon, or?
Why don't you go upstairs and bring a file and come on down?
Okay.
Meanwhile,
Okay,
we'll
thank
discuss
you.
a few other things. What about Senate Bill 649, Senator Hanger? We'll put that off too. This has to do with juvenile law enforcement records, disclosure to school principals.
I didn't get a notice on that one. I guess this is the last meeting, then we're.
Okay, it changes from discretionary to
I better
mandatory.
go get some. I better go get my files in.
Yeah,
y'all move along here, and I'll be back.
Okay.
Thank you,
All
Mr.
right,
Chairman.
we'll do that. Okay. Is Senator Evans not here?
Senator Norman's got to go.
Senator Norman, go ahead quickly. Okay.
Senator 148.
Senate Bill 140, public health emergencies.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I have Senate Bill 148, and an amendment in the nature of a substitute is being distributed, which I understand is the ultimate kumbaya between the healthcare providers and the attorney profession. Mr. Chairman, what this deals with is the immunity of healthcare providers, and it is in response to the most recent COVID situation that we have been through, and the amendment in the nature of the substitute really only changes what is on lines 14 and 15. The committee and the General Assembly has previously enacted almost all of the language that is contained in the bill, with the exception of 14 and 15, which is recited. And what it provides is that there is immunity in the absence of gross negligence or willful misconduct if a healthcare provider is responding or delivering services as a result of a disaster. And it adds, or who commits any act or omission as directed by any order of public health in response to such disaster. And you will note further on down there that the word state has been stricken, but you have in there local emergency, then a state of emergency or public health. And please note that that sentence is written in the conjunctive, so that you've got to have the intersection of both little I number 1 and little I number 2. It further provides over on line 32, it incorporates, there are a series of definitions under Title 44, and you will see that the definitions in there all relate back to the code section of 44.1 and 46.16. I do know that the healthcare providers and the legal community have worked on this, and I don't think that's any dispute.
Senator Peterson.
Okay.
Go ahead.
And I know it sounds like there's peace in the valley, but let me ask you, I mean, we had a state of emergency that went from March of 2020 to June 30th of 2021. That's 15 months, and I think every hospital or hospital system probably could have said during that time that they were shorthanded in one way or another. And does this not give them basically a hall pass on any acts of med mal during that time frame?
I don't think, and I'm certainly willing to hear from the healthcare providers, because I think they, and the trial lawyers, they would have a perspective on that. But, as you mentioned, Governor Northam did a declaration of a state of emergency that actually expired on July the 1st of 2021.
Yeah.
Which was a significant period of time in itself. Part of the trouble that we had is that it expired on July the 1st of 2021, and then we go through the sort of the culmination and the continuity of the COVID situation. And so that was part of the reason that this was coming forward, is because of COVID.
Okay. Any questions?
Is that close?
Chair.
Healthcare, health people. Yeah, health hospital. Yes, Senator Morrissey.
A question for the patron.
Yes, sir.
Senator, when the law was originally written, and I'm looking at lines 13 and 14, and it says, in the absence of gross negligence or willful misconduct, any healthcare provider who responds to a disaster, what was the context of those words pre-COVID-19?
I'm not sure I can give you a candid response to that, because I wasn't involved in the original bill on this. So that is, and I'm not being obtuse about it, that was a decision that the General Assembly had previously made and is not changed with the amendment that has been made to the existing law. So I just don't recall the history of it, to be truthful with you, sir.
Then, Mr. Chair.
Senator Deeds.
Well, then explain to me what an omission as directed by any order of public health on line 15 is. How are you directing a mission?
I'm sorry, I just didn't understand your question.
I'm sorry. How are you a direct omission as directed by any order of public health on line 15?
I think I'll call in the cavalry on that one.
I just need
know
an
what the answer
example
is,
of that.
but I don't want to misstate it.
Yeah.
Mr. Chair, members of the committee, Brent Rawlings, Virginia Hospital and Healthcare Association. I'll attempt to answer a couple of different questions here. Starting first with going backwards, Senator Deeds. order of public health research, are you, you talking about the act or omission language?
I'm
Yeah,
specifically
so,
talking
yeah,
about
so,
the
so an example would be, over the course of this, we've had several executive orders coming out from the governor and public health orders as well. One example would be the curb on elective surgeries or non-emergent surgeries. So, you know, if for some reason someone didn't get care during that time period and it was a result of the hospital or ambulatory surgery center ceasing services for that period of time, that would qualify for immunity here. Picking up on the other question, Senator Morrissey, you had a question about disaster. The definition of disaster is in 44-146.16. So if you look at that definition, I think I might have there we go, perfect. We have it here, and it's including man-made disaster. I'm just going high level. Man-made disaster, radiological, chemical, biological means. It includes in here also a natural disaster, hurricane, tornado, storm, flood, high water, wind-driven water, but significantly, it also includes communicable disease of public health threat. And really, the reason why, and I think now getting back to Senator Peterson's question, you know, we had the state of emergencies dropped July 1. Passage of time, we've been in the largest surge of hospitalizations that we've had since this pandemic began, close to 4,000 hospitalizations. It's been the worst that it's ever been. We're the closest that we've ever been to crisis standards of care. Some hospitals actually declaring crisis standards of care during this period. If at any time you need it, it would have been these last 2 months in terms of resource shortages, staffing shortages, all terms that are used here within this statute. And the only reason we haven't had it is because the trigger is the state of emergency. And so without that, we don't have that protection. And so in working with the legal folks, we really wanted to try to capture this period that we're in, where we do have clearly resource shortages. We are clearly responding to a disaster. We know we're putting ourselves in situations where we either don't have enough staff or we have critical resource shortages, more patients than you have staffed ICUs, people that need monoclonal antibody therapies that are not available, and you've got to make choices between patients. And so these are the types of circumstances we're hoping to address.
Okay. And Mr. Chairman, just to be certain, I did check with Mark Dix of the trial lawyers, just based upon the explanation that was given, that they were still good with the bill as it's proposed.
Okay, these doctors, got something behind you. Yeah, Scott.
Yes, sir, Mr. Chairman, Scott Johnson for the Medical Society and the Virginia Healthcare Association. One thing I would just share with y'all, I believe 22501 was passed in like 2005, and the other statute, I think in like 2007 or 8, and it had never been interpreted. And so we spent a heck of a lot of time with Rita Davis's and Governor Northam's office on Executive Order 60, trying to do what we're asking you to do in code now, so we won't have to have that rat race, God forbid we have another disaster or public health emergency.
Okay. Any
Mr.
further
Chair.
questions? Yes, Senator Morrissey?
I'm sorry, I forgot you're behind.
Oh,
yes.
Brent Rawlings.
Mo-
Brent Rawlings, Hospital
Rollins.
Association.
Mr. Rollins, a couple of questions. You answered my first question as to what disaster meant, and I understood that, and that's what I expected it to be. But tell me if I'm misreading this. Now, when we expand it to a healthcare provider who commits any act or omits during a public health, when there's an order of public health emergency out there, does that not expand hugely the amount of immunity we're granting to healthcare providers?
Yes, Mr. Chair, Senator Morrissey, I think that what you have here is an elaboration or clarification on what it means to respond to a disaster. Under any of this, when this is triggered in a public health emergency, you're still going to have to meet the elements of the statute, which are whatever it is has to be in responding to a disaster. There has to be an emergency and subsequent condition that caused a lack of resources attributable to a disaster. So we're not getting away from having to satisfy any of the elements of that statute. And again, we sort of look at that as a clarification from on the existing law.
Okay, Senator Morsi?
Any order of, the words, any order of public health on line 15, that would include the order entered by the governor during COVID-19. Is that right?
Yes, yes, and as well, there have been, Commissioner Oliver also issued public health orders. And these are things that have to do with, different guidance documents on staffing, PPE use, dealing with, as I mentioned earlier, the elective ban on non-emergent procedures, those sorts of things.
Well, let me ask this final question, and I'm going to
Senator
preface it with this comment. I can't begin to explain how grateful I am to the healthcare providers who provided help during COVID-19. And I remember in February and March of 2020, when nobody knew what was going on, and those healthcare providers, nurses, doctors, support staff showed up every single day. It was amazing. But it appears to me that what the language says is, if there is an order issued by the governor involving something like COVID-19, it excludes from liability any healthcare provider who, for example, committed an act or didn't perform an obligatory act during a lengthy period of time that is somehow has some tenuous connection to the emergency, COVID-19. For example, an individual comes in and there's an act that came in with a severe head trauma, but it was during the period that COVID-19 existed. Healthcare providers were stressed to the limits, and they did not provide assistance or aid to that person. They would have immunity.
Mr. Chairman, if I may
Scott.
answer Senator Morrissey's question, let me give you an example. So you've got 20 patients in a physician's office, okay? And that physician has got to run out, leave those 20 patients in there to go to the hospital. He's responding to a disaster. And while he is gone, one of those 20 patients has a heart attack. Arguably, this would apply. But if that physician is examining one of those 20 patients and ignores a symptom like chest pain and the person had a heart attack, even though it's during the pandemic or disaster, this immunity doesn't apply. They're negligent. They're going to get sued.
Where was the language for that?
If you look on line 15, response to a disaster.
Yes?
So your act or your admission has got to be in response to a disaster. It's not just because it happened during a disaster.
I think I'm accurate in saying, and I had conferred with the trial lawyers on, they actually put that language in there as a point of clarification to explain and put it in context with the previous language inserted in 05 and 07 was that they felt it needed to be clarified, and that's why it was put in there.
Okay, any further questions? All right, sir. Anybody want to speak in favor or against? You've already had people speak in favor. Anybody against?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised
Okay,
online.
is there a motion?
Move to report, please, sir.
It's been moved and seconded to report as amended. Senate Bill 148. All in favor of the motion, vote aye. All opposed, vote no. Yeah, and then do the natural, do the other one.
Ayes 11, noes 3.
Bill's reported,
I'm going to turn
Chairman
it over
Edwards
to
is now going to do Senate Bill 144.
Turn to Senator Deeds.
And he's got people here to speak to the bill, and so that's why we need to get it squared away.
Thank you.
Senator Edwards, but Senate Bill 144.
Yeah, Senate Bill 144, the dead man's rule. I have an amendment I'd like to offer now. Amendment to the bill. It's a substitute, actually.
Move to substitute.
Okay, all in favor of adopting the substitute, say aye.
Aye.
Okay, the substitute's before us. Senator Edwards, some of the members of the committee and certainly some of the members of the audience are not lawyers, so you might want to explain the dead man's rule and explain what it is this bill's about.
Let me explain the dead man's rule, if anybody can ever explain it. Here's why initially I put it in to abolish the dead man's rule. Right now, less than 12 states have the dead man's rule. It's not in the federal system. The dead man's rule is the rule of evidence. You can't sue a guy who's dead because the dead man can't speak. And the dead man's rule grew out of the 19th century. I could go on and on about this, but it was a 19th century idea, and it was passed in 1919 in Virginia when we did not have discovery. There is no discovery. In most cases, criminal and civil were tried by ambush as a practical matter. And Professor Sinclair has written extensively on it, and there are numerous problems with the dead man's rule. The first is that there are over 100 Virginia appellate cases.
But basically, the rule itself says what?
Well, I'm trying to explain it. The dead man's rule says you can't sue the dead man, but if you sue him, you have to corroborate your testimony.
I know.
And that's just one of the problems.
The evidence can't come in unless it's corroborated.
Can't come in unless it's corroborated.
Okay,
And
that's the dead man's rule, and
one of
that's what you were trying to do away with, and what's a substitute do?
Well, no, I'll get to that in just a second. The 100 Virginia appellate cases that try to explain what is corroboration, and they're all over the place. There's corroboration that's heightened corroboration. It's just impossible to understand it. It's very confusing. The second problem has to do with the hearsay exception that's wide open. There's anything that the dead man said comes into evidence, no limitation at all. And then there's also something having to do with the interest. The interested parties, and if somebody has an interest, then you got another problem. It's extremely complicated. That's why over the years, about 50 years ago, I think it was, about half the states had it, and then it reduced from about in 1870, 40% of the states had it. In 1950, 20% of the states had it. In year 2000, about 12 states had it. And now in 2020, there's something less than 10 states actually have the dead man's rule. It's not in the federal system at all.
Mr. Chair, I'm just trying to move things along. The bill with the dead man's rule says if it's uncorroborated, it doesn't come in. And instead of just wiping out the code section, you're saying there's not, and lines 26 through 28, that if it's relevant, anything he said, anything the dead man said, any entries, memoranda, declarations by the person or incapable of testifying made while he was capable, relevant to the matter and issue, shall not be excluded as hearsay.
Right. Yeah, let me explain that. And I'm going to introduce the person that came up with the ideas, the rule. And Tom Williamson practices law here. He's a trial lawyer, and he's written extensively on the dead man's rule. And he's come up with a substitute, which I've adopted, which is the only thing that can come in if a guy's dead is anything the defendant, the dead man, says that's relevant to the case can come in. No corroboration. Corroboration's out. It's too complicated to explain.
So if it's relevant, it's going to come in anyway, but it's got to be corroborated. And the only thing this does is say if it's relevant, it comes in even if it's not corroborated.
Right, because the corroboration rule is just all over the place.
Okay.
And the reason for this is you can always cross-examine a person, and in cross-examination, you can impeach the person that comes in to testify on behalf of the dead man. So Tom Williamson is here. I've spent a lot of time talking to him. He's written extensively on the dead man's rule. And he and others have come up with the idea, here's a way to resolve it without just repealing the whole thing. So Tom, introduce yourself. He's a lawyer here in Richmond.
Thank you, Mr. Chairman. As you know, I'm Tom Williamson, and I have, over the course of my career, I've litigated in the trial courts and in the Supreme Court of Virginia issues arising out of the dead man statute and its application. I've also done a number of CLE presentations and writings, and a couple years ago I chaired a Boyd Graves conference committee which studied the dead man statute. When the chairman brought to my attention the original version of SB number 144, I told him I was opposed to it. And the reason I was opposed to it, it would have repealed both branches of the dead man statute. The dead man statute has basically two legs to it. The first is the surviving party or interested party has to have their testimony corroborated. The other branch of it is with regard to a deceased or incapacitated party, is their statements come into evidence if they're relevant. And I thought the second branch, with regard to the statements of the deceased party, that was worth saving. As to the other branch, the corroboration branch, I don't feel that way at all. Why should we save the branch that gets in the statements of the dead man? There are cases where without that, the dead party's version will never be fully presented to the court, and you'll have the surviving party will have free running room. This statement, where it does need to be changed, is in its present form, which has been that way since 1919. It said, if the statement of the dead incapacitated party is relevant to the issue, it shall be admitted. I submit that ought to be changed to, as you can see in this version, to shall not be excluded as hearsay, meaning all the other objections to it saying that the witness isn't competent to make that a statement. For example, if the statement of the deceased party constituted an expert opinion that they weren't qualified to give, you could still exclude that. So I think that's a change worthy, especially in light of the recent Shoemate case, where Justice Mims, speaking for the majority, pointed out this anomaly, that this is more than just a hearsay exception in its present context. And I think it's already been mentioned, this is not doing something radical, saying, well, oh, if we let in the statements of the dead party, it's going to be something radical. We've been doing that since 1919. And I don't know of any Virginia Supreme Court case or any other reported opinion that suggests that this is going to be some type of travesty to let in the statements of the deceased party. It's been working for a long time, and it seems to work well.
Let me ask you, though, on line 14 and 15, you're taking out the language about the statements that the uncorroborated testimony that we weren't able to come and bring it in before, but now you're going to allow that to come in under this bill. Is that correct?
Yes. And why is it that is a appropriate thing to do? The prohibition against uncorroborated testimony of a surviving party, that's a vestige of English common law that we inherited in 1790. And at common law in England, any interested party was an incompetent witness. You couldn't testify at all. So you would try cases without either of the parties to a transaction being permitted to testify. In the 19th century, this situation began to reform. And Virginia, starting in 1866, had a series of statutes that culminated in 1919, where they said, okay, we're going to let it in, a surviving party's testimony, even though they're interested, if there is corroboration. And since that time, we've had tremendous litigation about what is sufficient corroboration. Is it a question for the jury? Is it a question for the judge? What if there's a confidential relationship? And I submit that we don't need all of that we can trust the trier of fact to determine whether or not this uncorroborated testimony of the surviving party should be given any weight whatsoever. And especially in the environment we have now, where we have liberal discovery and the estate or the representative of the deceased incompetent party is going to know months before that case is tried what is going to be the testimony at trial that's uncorroborated coming from that surviving party, and you'll have all the opportunity to turn over all the rocks to develop a case that that's not worthy of belief. So it's fine with me to let that slide, do away with the corroboration requirement, but I think you should preserve a hearsay exception for the deceased incapacitated.
Okay, thank you, Mr. Williamson. Are there other people that want to speak in favor?
Mr. Chairman, I have a question.
Senator Peake.
Mr. Williams, all right. So looking at, is this the correct one?
That's the correct one, yes.
So Mr. Williams, Mr. Chairman.
It's
all right,
10:58 a.m.
Okay.
That's what.
So if what you're telling me is true, let's say there's a medical malpractice case.
Yes.
Under this new proposed statute. And a guy was injured by a doctor, and they've got a lawsuit going on, and the doctor dies. And the patient who is suing him says, and by the way, the doctor came over to my house last week, and he said he is sorry he butchered me, but he was drunk and stoned when he went in for that operation. That comes in.
Well, it would come in as an admission of a party opponent.
Right, but if we don't change the law, it would not come in unless somehow that was corroborated, correct?
Well, yes, you would need some type of corroboration for the patient to say, yeah, that's what
To get him over there.
the doctor
I
said.
heard him say that or something. Then, Mr. Chairman, same question.
Senator Peake.
You said has Boyd Graves produced any recommended change or proposal on the dead man statute?
In 2017, the committee that I chaired, and Kent Sinclair was on that committee, the committee recommended to the conference that it change the hearsay exception to make it clear it only applies to hearsay in terms of the statements of the deceased incapacitated. The full conference did not endorse that, and for that reason, it was never brought to you by the conference in 2017.
Senator Peake.
So for 100 years, since 1919, now 103 years.
Yes.
We've been operating under the same theory.
Yes, there have been a few tweaks along the way, but it's also on corroboration, as the chair has pointed out to you, has produced a myriad of opinions. And it's a very hard thing to make a firm prediction about what's going to happen on corroboration.
Okay, are there other witnesses, Mr. Chair? Are there people who have another view of the bill? Have you seen the substitute, Mr. Dix? Have you?
Yes, Mr. Chair, I have. Thank you.
Okay.
Mark Dix on behalf of the Virginia Trial Lawyers Association, and we must respectfully again oppose this bill. We understand the intent of the bill. We understand the genesis of the bill, but we just have a difference of opinion on policy. Is the dead man statute a perfect evidentiary rule? No, it's not. Sometimes it's going to help you in a case. Sometimes it's going to hurt you in the case. Sometimes it helps a plaintiff. Sometimes it helps a defendant. Sometimes it helps a decedent's estate. Sometimes it doesn't. But that's true of all evidentiary rules, including hearsay, and we're not about to abrogate hearsay. And the public policy behind an evidentiary rule that doesn't allow the use of a deceased person's statement against them without a corroborating witness is sound. They're not there to defend themselves. And it's oftentimes said that we live maybe in a post-factual world where rhetoric is more important than facts. This is not the kind of thing that we just avoid a gatekeeping function. The dead man statute provides a very important gatekeeping function from someone who can't defend themselves. We've sent this matter to Boyd Graves twice, 2013, 2018. It didn't work. We hope it doesn't go back to the Boyd Graves spin cycle again. That would be one thing we really hope doesn't happen. And we've spent countless hours internally wrestling with this. We have a past president of our organization who has a different view. It's just a matter of public policy, and we just don't see eye to eye. We appreciate the patron hearing our concerns, and we hope that the committee will PBI the bill.
Mr. Williamson is the past president of your association.
That's correct. It was a long time ago.
And Senator
Not
Edwards.
1919, though.
Senator Edwards, it was your bill, I guess it's Senator Boyd Graves in 2012 or 2013, and also in 2017 or
They
2018.
ignored it. To my knowledge, they didn't do anything. They just never did anything. And they're trial lawyers that I know very well, close friends of mine, that just would like to abolish the whole thing, because and the other thing about corroboration is, as they mentioned, over 100 cases, they're all over the place. You can't predict what the corroboration
The
is.
thing is, there are some trial lawyers on this committee, there's some people that aren't lawyers at all. And I don't know that you're gonna get any consensus about change here. Is there anybody else to send it to produce something you can be satisfied with?
I guess we could maybe send it back like we did before to the Civil Law Subcommittee. We actually had a proposal back in 2020, I believe it was.
Well, why
And
don't we carry it over and ask the Civil Law Subcommittee to take a look at it? I don't know that we're gonna.
I think something needs to be done. I mean, it's all over the place. I've talked to very experienced, intelligent attorneys.
Okay.
They don't understand it. I have a good friend of mine who went to Harvard Law School. She called me up in September 2020. She said, I've been spending 2 weeks trying to understand it. I don't understand it. It's the most confusing thing in the world. That's the problem. We need to figure it out, make some sense out of it.
You may wish to make a request to the Boyd Graves Conference that they revisit it if you're going to carry it over till next
Well,
year.
I don't, Senator Servell, I think has a motion as something.
Yep, no, Mr. Chairman, I think you have an excellent idea, and I think Senator Peterson who's not here, was talking about having a civil sub meeting for something else. So I'd move that we carry it over to 2022 and refer to the civil subcommittee in the meantime.
Yeah, that's fine. But they did study it in 2020 with Kent Sinclair, and they recommended a change. I forget what it was.
This would be something, Civil Law Subcommittee, that you would be part of.
Yeah, sure.
So we got a motion and a second on the floor. All in favor of carrying the bill over to 2022 and referring to Civil Law Subcommittee, vote aye.
That's 14-0.
Mr. Chairman, I know there's another bill you want to take up. Senator Boysko's got some witnesses here. Can she take up her bills first?
Yeah.
Okay. Senate Bill 453.
I really appreciate that. They were here last week for the entire hearing and we didn't get to this bill, these two bills yet. Mr. Chairman and members of the committee, first I have a technical amendment.
Please state your technical amendment. Has that been distributed?
Mr. Chair, it has not been distributed yet, but basically the technical amendment, if I can find it right now.
Are we in 453?
Line 102.
Right, it's on line 102, it's strike after the defendant is guilty of a class 1 misdemeanor. The bill as introduced basically provided that if someone was on the autism spectrum, they would not be guilty of the class 6 felony in the bill for assault and battery against a law enforcement officer. They'd be guilty of a class 1 misdemeanor, and it was unclear from the bill how that would work. So this just strikes that and just purely states that they wouldn't be eligible to serve they'd be excluded from the mandatory minimums.
Okay. It didn't say anything about law enforcement assault in here, but the way I read the bill, I knew it would only apply to that.
That's correct.
So you're striking, you're saying they can still be convicted of a felony, they just wouldn't be subject to the mandatory minimum. Does everybody understand that amendment? Is there a second? Okay, all in favor of that amendment, say aye. Aye. Okay.
Okay.
Senator Boysko.
Thank you. So this is, this is a very tightened up onion ring bill. As you remember, 2020, we had a bill on assault on an officer. This specifically says that any person charged with a simple assault and battery offense who has been diagnosed by a psychiatrist or a clinical psychologist with an autism spectrum disorder, an intellectual disability, or mental illness, and the violation was caused by or had a direct and substantial relationship to the person's disorder or disability shall not be subject to a mandatory minimum punishment. Under the current law, certain simple assault and battery offenses carry mandatory minimum punishments when such offenses are committed against certain groups of people, including law enforcement officers. We know that when in the same position as a neurotypical person, people with these disabilities may not make the same choices or experience the same reactions to a given circumstances. They may experience an involuntary reaction, lash out in situations in which they feel threatened, especially by an authority figure. Cases of assault and battery against a law enforcement officer or educators, healthcare professionals are not the same as when perpetrated by neurotypicals with the ability to distinguish their actions between right and wrong. You got it?
We understand.
You've seen this bill before, it's
I was
tightened
wondering
up.
if it might tighten it up even more if you further define mental illness on line 100 as serious mental illness. So anyone diagnosed with a serious mental illness.
Well, we would like to make sure that it includes people on the autism spectrum.
Well, you've
So-
already said that.
Okay.
So serious mental illness.
Yep, I would be willing, I would
Does that
consider that a
make-
friendly amendment.
Okay.
That'd be a friendly amendment, Mr. Chair. I
Okay.
think.
All in
Mr.
favor?
Chairman, I'd say I like the bill the way it is, but whatever, that's what you want.
Well, it's serious, I'm just trying to think about something that might make it all the way through the process.
If you think that would help us
Okay.
get this through committee, that'd be
All in favor
great.
of that amendment, say aye. Okay. So serious mental illness, and you have people that want to speak to this.
I do.
bill. Okay.
Mr.
Okay.
Chairman,
I would ask for no more than, say, 3 minutes per
Mr.
side.
Chairman,
Senator Serville.
sorry, I just want to make sure I understand exactly how this will work as a practical matter. So we're not stating it's an affirmative defense. So would there be like another jury instruction and the defendant would put on evidence, including, professional psychiatric evidence as part of the defendant's case in chief?
Senator
So-
Serville, the way I would read this, the way it's been amended now, it doesn't go to the jury at all. It's after there's been a finding of guilt. The minimum mandatory sentence doesn't apply, and so it would go to the judge, who's the sentencing authority. Am I correct?
Well, I mean, under Mark's bill, if they choose a jury to do something, then. I guess if they choose to have a jury do sentencing, then I guess it would be relevant, but if they're having the judge do it, then the judge would just take.
Charles, what do you think?
Mr. Chair, it doesn't have to be in the case in chief. I think this would be in the sentencing phase. To the extent that the defendant does elect to have the jury recommend sentencing, I'll say this, I am uncertain if that needs to go to the jury or if the judge can make the finding himself after the jury returns their recommendation. I would tend to think it'd be best with the judge, and if we need to clarify that, that could be clarified in concept.
Since the sentencing issue wouldn't be before the jury, I'm not sure how last year we allowed the entry of certain evidence with respect to mental health to go before the jury, and I think it would be relevant. If it's relevant in that case, it's relevant. But the sentencing issue is one that's usually for the judge.
Mr. Chairman, but you can also elect a jury a jury sentencing. Say you have a judge who you don't think they might not be fairly judge the issue. You might want to get a jury to decide this issue for you.
Senator
Yeah.
Morrissey's got
The
something.
fact finder could be a jury, so why don't we just put after 100, and the court or fact finder?
Second.
Where exactly that?
Line 100, Mr. Chairman, under Roman numeral small 3I, mental illness, and the court or fact finder.
And the court or fact finder finds by clear and convincing evidence. So it's after "and the court"
Yes,
or fact finder.
or fact finder.
Second.
Okay. All in favor of the amendment, say aye.
Aye. Mr.
Okay.
Chair.
Senator McClellan.
I also want to clarify, as I understand, simple assault and battery is a general intent crime. So my bill, is that accurate?
Assault requires an intent, I thought. Intent to create fear.
Look, Charles?
Mr. Chair, so assault and battery can be committed by a mere offensive touching, which is a general intent.
Right, so if this is a case where there is no intent, my bill wouldn't apply. So that's why, that's an extra reason why this is important, because if you have a case where it doesn't matter whether you had the intent or not, no evidence of your autism or severe mental illness is going to be allowed. So it's just to allow it to come in at the sentencing phase if it's relevant to that case.
Thank you.
Okay, well, do 3 minutes for, 3 minutes against.
Quick. Brian Kilmar, Executive Director of Elred Legal Reform for Intellectually and Developmentally Disabled, also retired Navy commander, and I have a son with autism. And we support this bill. We have families that get in trouble with their autistic children going into breakdowns or meltdowns and accidentally hitting people, not intending, and then we end up needing to get them lawyers and spend thousands of dollars to get them out when it was nothing more than he was just having a meltdown, and they end up in prison. So we support this bill.
Okay, thank you, sir. Yes, ma'am.
Hi, Jude Harrison, I'm Director of Communications for Elred, and for all of the reasons that Brian just said, we fully support this bill.
Thank you, ma'am.
Hi, Tanya Milling, Executive Director at the Arc of Virginia. We're very appreciative and do support this bill for all the reasons mentioned. Thank you.
Thank you, ma'am. And there are people online. Is that correct?
Yes, sir. Anna Mendez, would you please unmute?
Good afternoon, Chairman. My name is Anna Mendez. I'm the Executive Director of Partner for Mental Health in Charlottesville, Virginia. Every single one of our clients who has been charged with felony assault on a law enforcement officer has two things in common. One is that they received the charge after a loved one called 911 for help, not to report criminal activity, and they had no intent to harm anyone. We support this bill on the strongest, most possible terms, and I am also available to answer any questions that you or the committee may have. Thank you very much.
Thank you so much. Yes, ma'am. Next.
Genevieve Miller, please unmute and begin your testimony.
Genevieve Miller, Deputy Public Defender with the Prince William County Public Defender's Office, and appearing here today on behalf of Justice Forward Virginia in strong support of Senator Boysko's bill. Just from a snapshot of my work as an attorney and seeing the sorts of cases that public defenders routinely see for folks charged with assault and battery on law enforcement, as Ms. Mendez has stated and the in-person witnesses have highlighted as well, for folks with intellectual and developmental disabilities, this is not something that has intent to it. These are involuntary reactions. These are perceived threats. These are folks trying to keep themselves safe from what they perceive because of their own subjective matters. And so we'd strongly ask the Senate to consider supporting this bill.
Thank you, ma'am. Next.
Teresa Williams, please. Teresa Champion, please unmute.
I know where she is.
Hi, good afternoon, Mr. Chairman, and I'd like to thank Senator Boysko for bringing this bill. This is so very important to our community. I'm Teresa Champion with the Virginia Autism Project, and no one with special needs is reading the code and thinking that this is an open door to assaulting someone. That argument has been stated by law enforcement. It's patently absurd. This will allow families to call for help with the relief that their loved one possibly won't end up with a felony charge.
Thank you.
Support this.
Thank you, ma'am. Okay, are there people that have another view?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
One person back here.
Good afternoon, Mr. Chairman, members of the committee. I'm Brian Haskins, Pennsylvania County Commonwealth's attorney, speaking on behalf of VACA. VACA opposes the bill for two reasons. First is the general issue is that we already have a statute 19.2-271.6, which was passed last year, that allows for the introduction of this evidence to begin with. The second issue is the definition of mental illness, which I know we've amended. We had this same issue come up last year in that other bill because the language is identical. Mental illness is defined in this statute, which says means a disorder of thought, mood, perception, or orientation that significantly impairs judgment or capacity to recognize reality. That's on line 79 and 80 in this bill. Last year, the same language, and it is in the statute that we just passed last year, 19.2-271.6. VACA gave an opinion which I believe everyone on the committee agreed with, that opened the door to voluntary intoxication.
Mr.
And-
Haskins, do you agree with Senator McClellan that her bill requires a specific intent crime before?
Oh, yes.
That evidence comes in, and assault and battery is not a specific
Assault
intent?
is, battery is not. So I do agree with that. But a critical issue that we identify in this bill is that language of mental illness as it's defined right now, and it is fixable because we fixed it last year. And I'll tell you how we did it. That language includes voluntary intoxication at this point. The language stayed the same in 19.2-271.6, and this committee, I believe, fixed that bill by including a paragraph G in that statute that says nothing in this section shall be construed as permitting the introduction of evidence of voluntary intoxication. That was added in 19.2-271.6, and it became law. If that language is not included in this bill, then it will be construed as the legislature specifically adopting voluntary intoxication for this bill.
So your view is voluntary intoxication is mental illness?
Well, the definition of mental illness, a disorder of thought, mood, perception, or
But we've already
orientation.
defined it as a serious mental illness in this bill.
Sure.
And that's a pretty specific term, too.
Well, if it's defined, because right now, when you add serious mental illness, the definition continues to read the same, which means a disorder of thought, mood, perception, or orientation that significantly impairs judgment. It can be fixed.
Yeah.
I would propose that fix of adding the language that says nothing in this section shall be construed as including voluntary intoxication, because we've done that in the other bill to fix that bill, and leaving it out here by omission is a statement that voluntary intoxication
Okay,
should
Senator
apply.
Norman, then Senator Morrissey.
Mr. Chairman, just sitting here noodling.
Senator McClellan and Senator
I don't know that picking up that language hurts the bill at all. I think it still has the underpinnings of exactly what the senator is trying to do, and if it gives VACA some comfort to explicitly exclude voluntary intoxication as we did in the other bill, I don't think it diminishes the impact of this bill at all. And I would just say, I'm really enthusiastic about this bill because I'm defending one of these cases right now on autism.
So Senator Norman moves that we include that language in the.
Yeah, second.
Second.
Okay, and it might be by concept, exactly where it fits. Senator Morrissey, Senator McClellan, Senator Saslow, do you all want to speak to that issue, or you want to go to something else?
I want to speak to something that I witnessed.
And I want to go to something else.
Okay.
Let's just, so that we're all on the same sheet here. It's Mr. Haskins.
Yes, sir.
Mr. Haskins, Senator McClellan's bill last year allowed into evidence during the guilt or innocent phase, evidence of mental health, illness, whether the person was on the spectrum at all. That would go to whether the person was found guilty or innocent, and it became relevant. Senator Boysko's bill has moved beyond that, and it said, okay, you've already introduced evidence of his mental health deficits, but the person was found guilty. Now all this bill is saying is that the person is not subject to the mandatory minimum of 6 months. Would you not agree that that's the case here?
Yes, sir. Mr. Chair, and Senator Morrissey, I absolutely agree with that.
Okay.
And I've heard the committee speak about whether this is a jury issue or not. In a case where a jury is entitled to recommend a sentence and the defendant demands it, I would submit we'd run into a Ring versus Arizona problem of denying the defendant the constitutional right of having the jury of his peers choose the aggravating or mitigating factor. So the jury would have to make that determination. It wouldn't be something that a judge could do, in my opinion, if a defendant demanded that the jury be the one who tries his case and sentences the case. But I do
Mr.
agree.
Chairman, okay, what's going to happen is this. During the trial, there's going to be evidence of mental health deficits, whatever, spectrum. And the jury or the judge will determine whether he is guilty or innocent and consider that relevant evidence. It's only after the jury rejects that evidence, finds the person, or the judge finds him guilty, that you're now saying to the judge or to the jury, okay, you found him guilty, but you cannot sentence him to a mandatory minimum.
Yes.
I think
But
that's.
you agree that the putting the voluntary intoxication language in here does not hurt the cause?
I agree.
Oh, Senator McClellan, did you have something you wanted to say before we adopt the amendment? Do you want to talk, Senator Saslow?
Yes, sir.
Sir, I want to describe a situation that I personally witnessed. At the time, I owned a lot of gasoline stations. And one of them was at one of the busiest secondary road intersections in Virginia. To give you an idea, it's almost 90,000 cars a day through that intersection. And there's a school nearby that has kids, that does nothing but handle kids that can't, get along in a normal school environment. And apparently, one of the girls at the school, and it was brought to my attention, my office was near there, she was out in the middle of the intersection screaming at cars going by. I mean, she was lucky she didn't get hit, but she was screaming at cars. And pretty soon a police car pulled up, Fairfax County, and the policeman got out of the car. And he went out there into the middle of the intersection. And ultimately, he was able to talk her over to the curb. And as it turned out, one of the parents forgot to give the kid that medication. It got pulled up because they had been called as well and told the policeman that it forgot to give the medication. Let's just suppose that while they were out there in that traffic, she swung at that policeman, hit him in the face, say, just with her fist, bruised him. Do you really think she should have been charged with a felony? You really think so, given the circumstances I just described?
Yes, sir. Mr. Chair, Senator Saslaw, I can speak for myself. I can't speak for VACA on this
Sure.
because we're 120 independent elected princes and princesses, as it's referred to sometimes. I'm one of those princes. In my jurisdiction, that individual would not be charged with a felony, or if the officer charged them with a felony, because they don't always consult with us before they run to the intake officer or a magistrate, depending on the age of the individual involved. I would work with trying to reduce that. And your case doesn't involve voluntary intoxication like our concern is. Our concern is that voluntary intoxication being prohibited in the guilt phase,
Right.
and then shows up in the sentencing phase. Well, now let's go talk about that he was drunk and he deserves it because he was drunk. That's our concern with the sentencing issue.
Senator Morrissey's got something.
Mr. Haskins,
Yeah.
I'm not practicing law now, but it was my experience when I was that in every situation where an LEO was struck, he was charged with, or she was charged with the felony, what Mr. Saslaw was referring to, and then it was used to negotiate down. Do you agree with my observation that almost always, if not always, the defendant was charged with the assault on an LEO, the felony assault on an LEO?
Mr. Chair, Senator Morrissey, I agree that most, I can't think of one that wasn't charged that way because they typically don't call me in the middle of the night and say, hey, this has just happened to me. It's a shift sergeant saying, book him, Dano, and off they go, and we have to deal with it. But to address the issue of pleading charges, and I'm speaking again only for myself and not VACA, I personally believe that you charge someone with a crime, you're affecting their life path. And if to use that as a bargaining chip to bargain down a case is, to me, something that I would never do, and I do not do, because I think it's improper to say, well, will you trade the microwave for what's behind door number 2 because I got a charge on you that neither one of us really thinks we ought to be prosecuting.
Senator McClellan.
Mr. Chair, so I have a question, and then I have another example for
Yes,
actual
ma'am.
case. My understanding is one of the justifications used for mandatory minimum sentences is that they're a deterrent. Is that your position or VACA's position?
Mr. Chair, Senator McClellan, that has often been VACA's position, and mandatory minimums have been argued both ways by the Commonwealth in this sense, as a deterrent and also to incarcerate those who are more violent, to deal with the violent population by incarceration and
Okay.
not deal with the nonviolent population since we don't have mandatory minimums.
Let's take the deterrent piece. If you have, and I'm gonna give you a real life case.
Okay.
Someone was charged in Lynchburg where you are not the Commonwealth's attorney, so they are not as progressive as you.
Mm-hmm.
There was a student who was autistic who was sent to the principal's office, who stopped to drink at the water fountain. He had sensory processing issues. A school resource officer grabbed him, and he reacted, and in reacting, touched the school resource officer. He was charged with felony assault on a law enforcement officer, and that's a felony, where in that case, that if he was found guilty, a mandatory minimum would not deter an involuntary reaction to being touched when the way your brain works, if you're touched, you automatically react. Touching a police officer in that situation does not per se mean that person is violent. And the point of this bill is to say, let the trier of fact decide in deciding sentencing whether that person needs to be incarcerated for 6 months or 2 days or not at all. That's the point of this bill. And I want to highlight something one of the witnesses said. I can't tell you how many people, when a family member is in the middle of a mental health crisis, are terrified to call the police because they're worried their child, usually, will end up dead or thrown in jail. I've had parents call me when their child is in the middle of a mental health crisis and say, I'm scared to call the police, what should I do? And that is what these bills are about.
Isn't that so? Now, we've got an amendment before us. We've got an amendment before us to adopt the involuntary or the voluntary intoxication language. Did everybody understand the amendment? Everybody votes yay for the amendment?
Yes.
Yay? Okay,
Aye.
aye. Vote nay. Any nays? Okay, the amendment's adopted. Are there further motions on the bill?
Second.
Okay, all in favor of reporting, vote green. Okay, we've got one no, two noes, usual suspects,
Tough customers.
tough customers.
Yep.
Ayes 11, noes 2.
Okay.
Thank you.
We've got one more bill, Senator Boysko, and Senate Bill 443.
Yes, sir. On this also, so this is sealing of offenses resulting in deferred and dismissed disposition or conviction by petition, and I do have an amendment.
Mr. Chair, on line 24, after years, insert or within the past 10 years in the case of a defendant with a disorder or disability.
Okay, does everybody understand the amendment? Is there a second? to the
Second.
amendment? Okay. Okay, all in favor of the amendment, say aye.
Aye.
Opposed, no. Okay, the amendment's adopted. This bill basically allows people who have developmental disabilities or autism to
Petition.
have sealed up to class 4 misdemeanor, class 4 felony.
Petition a judge to do that, yes. It doesn't happen automatically.
That's right.
It would make the request. And they would have to have, no convictions within past 10 years. They have to be spotless. We know that there are hardships for these families. They can't get their kids in, the parents are aging, their kids have a record. They can't get them into any sort of a living facility. They're having a hard time getting any sort of simple employment, like just, working behind a counter somewhere. I have parents who are here again today who wish to talk about it. As we have aging parents of these individuals who are desperate to make sure that when they're gone, there is some way for their children to live.
And this disorder or disability on line 20 is defined over in the last paragraph, P, which is autism or an intellectual disability.
Mm-hmm.
Okay. Does everybody understand the bill? Okay, 3 minutes for people that are in favor of it and 3 minutes for people that are opposed.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
Okay. Yes, sir.
Okay, again, Brian Kelmar with Elred. As you know, there's 1 in 44 children today with autism with lifelong disability. There's currently no cure. These are people who depend on their parents for their management of everyday executive function. Many parents have recognized that they're going to be their child's caretakers for the rest of their lives. No one can ever imagine the devastation what our families go through and the struggles that we have even day to day with our loved ones, with those with autism, let alone those with a felony. And autistic struggles to understand the world around them, let alone having a felony for the rest of their lives. This amounts to a social death sentence to an already socially challenged individual. 85% of autistic individuals are unemployed or underemployed. This goes up to near to 100% if they have a felony, furthering the odds that the autistic will be dependent on their family members forever. These convictions disqualify the most vulnerable society from those supports of Section 8 of the housing assistance. Most apartments won't even rent to those with convictions. They can be banned from group homes and even nursing homes when they're 95 years old and can't walk or can't speak. This put these individuals at the highest risk of ending up homeless. This bill helps families that have fallen through the cracks in the criminal justice because we have not addressed autism in the criminal legal system until the past few years. As our current Attorney General, who's been a supporter of those with autism, so elegantly said, these are very, very unique situations, and I just want to say that our family members are hurting, and we need to give them some help so they have support, hope, and a chance at life. Thank you.
Yes, ma'am.
Yes, I'm Jude Harrison, Director of Communications for LRED. I'm also the mom of an autistic young man who has a felony conviction, and his life is truly a nightmare. So I ask you to please consider and support this bill. I don't know that you know this, but the reason for the 10 years is that the average lifespan for an autistic person is between 35 and a half and 58 years old. So that would be a really good reason to give them that extra 10 years of possibility. This is not a go free pass. They have to go before a judge, and thank you very much.
Thank you, ma'am. Yes, ma'am.
Thank you.
The Arc of Virginia very much supports this bill. Thank you.
Thank you, ma'am. Yes, ma'am. Yes, sir.
Mr. Chairman, Mike McMillan with Justice Forward Virginia. We support this bill. It doesn't change any of the mechanisms of the record-sealing bills that have already passed,
Okay.
just expands the eligibility pool.
Thank you very much. And there, we've got one woman online. Yes, please.
Teresa Champion, would you please unmute?
This is Teresa Champion with the Virginia Autism Project, and we support this bill. Thank you.
Thank you very much. Yes.
13 seconds to let.
You've still got about 10 seconds?
Yeah.
Okay. Are there people that are opposed to this bill?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand
Mr.
electronically
Haskins, come
now.
on up.
Yes, sir. Mr. Chairman, members of the committee, good to see you again. VACA has asked me to come and express its consensus opposition to the bill. One of the significant issues that VACA has with it is when you go into Class 4 felonies, you're talking about things like street gang participation with a juvenile, carnal knowledge of a child between 13 and 15, maiming someone while driving under the influence, attempted rape, attempted sodomy, object sexual penetration, embezzling, trafficking in firearms, and 18255, which deals with human trafficking. Those could be sealed, and that's where we are.
Understand that.
Thank you.
I don't know how many people have autism or are intellectually disabled that are convicted of those sorts of offenses.
True.
Thank you.
Okay, are there other people that are opposed? Okay, the bill's before the committee. Got a motion and a second to report the bill. All in favor, vote aye. Okay, so the bill's reported with the usual suspects being in opposition.
Thank you.
That's 11, those two.
Senator Hanger is back with his bill, and I think Senator Edwards is going to take over this.
All right, Senator Hanger.
Thank you, Mr. Chairman, members of the committee.
Together? Okay.
Apologize for not having my file with me. Half of my bills came up this afternoon in different committees, so I'm here on.
Is this 649?
591, if you want to take that one first.
Okay, 591, cannabis.
Thank you, Mr. Chairman, members of the committee. The substitute bill, which was adopted, the substitute bill, which was adopted in the Rehab Committee, it's gone through several hours, actually, of testimony. Senator Serval was involved with that. Senator McDougal not here. A couple others members of the Rehab Committee. The bill began as an effort to basically put under control the marijuana products, retail marijuana products that depict the shape of humans, animals, and various other entities in gummies, what we would commonly call gummies that are sugar-coated. And I think there's broad support for that. Also, And this subject developed when I was serving on the landing team for Ag and Forestry. I'm a strong supporter of introducing and expanding the growing of hemp throughout the Commonwealth. And that's a good thing if you're talking about construction products and bedding and all types of rope, clothing, traditional uses of hemp. But there's a product now where there is methodology where you can extract some of the, I call it juice, but extract the products from hemp in a concentrate that you can inject. It's called Delta 8, and it is arriving to consumers in various products, many of which appeal to children, are in edibles. We came up with a bill, a substitute bill, which essentially limits that product to a controlled environment where we set up the Cannabis Control Authority. They would either have to be properly licensed to retail these products, or they could be a scheduled product for other products that end up on a schedule. It could have been reported to the floor, but I think a couple of, particularly Senator Serval, thought that we could take it from the criminal subcommittee and maybe talk about it a good while and try to make sure we were okay with things. I feel like we're there, but and also I represented that at that point I had a sheet of paper that said there was no fiscal impact. We since have like the Woodrum Amendment, which requires a more timely advancing, or if you don't advance it, it could stop right here. But I would hope you would look seriously at this. Senator Stanley and I have worked on this together. He's in full support of this, but I'm taking the lead, and we're here to get your all's opinion.
Yeah, Senator Serval. Go ahead.
Thank you, Mr. Chairman. So I appreciate Senator Hanger's journey. It's been quite a journey, and the bill's been through quite a number of iterations. The reason that I thought it needed to come here was two. Number one is the original bill deleted the authority for marijuana field tests. And the reason we were given for that was because DFS indicated there were no field tests that could differentiate between marijuana and hemp, or the different types of marijuana that are reflected in the new definition of marijuana. Senator McDougal and I raised that in rehab, and we put that back into the code and out of the bill, because I guess the language is written says you're only allowed to use a field test if it's been approved. And so DFS might be able to approve a field test one of these days. Right now they can't. But we just left it there so we wouldn't be back here amending it again. But the other reason was 2 years ago we changed the definition of marijuana. There was a bill I carried at DFS's request to differentiate marijuana from hemp, because DFS was having issues with that. So they created it. They wanted to define it as Delta 9.
No, we got to meet Monday morning.
I wanted to make sure this bill redefines what marijuana is. And before we stuck this into the code, I wanted to make sure that DFS was capable of testing whatever products they get, and they can differentiate this new definition of marijuana from hemp in criminal prosecutions going forward. And so I know Ms. Linda Jackson's here from the Department of Forensic Science.
Is there an amendment to this bill?
And I think we need to hear from her to confirm that the Department of Forensic Science will be able to support prosecutions going forward.
Have we adopted the substitute, Mr. Chairman?
I don't think we've adopted.
Mr. Chair, there is a judiciary substitute, and it's, one of the changes is mostly technical, dealing with THCA, the tetrahydrocannabinolic acid.
Well, I would move we adopt the substitute.
Yeah, I'm not sure.
So moved.
Does
Second.
everybody have the substitute? I'm not sure. Do we have it? I don't.
So
I
I
don't
know
have
we
it.
passed
Okay.
some of the versions.
Hand out the substitute.
Substitute was handed out.
Mr. Chairman, the major changes that are embodied in the bill were adopted in the substitute in the Rehab Committee. What you have in front of you, I believe, is a substitute with technical amendments. Is that
It's
correct?
technical amendments, and then Senator McDougal wanted to schedule 2 THC derivatives, which appear in the substitute on lines 1233 to 1236. I could try and read them, but it's...
Is there a motion to adopt the substitute?
So moved.
Yeah, all in favor of adopting the substitute, say aye. Aye. All opposed, no. Motion carries. All right, we got
Mr. Chair, the
substitute,
lines
yes.
1233 through 1236 look more like computer code than they do words.
Mr. Chairman, those were ones in our conversations through the subcommittee, and Senator Serval and I asked DFS. They indicated that those 2 lines of computer code, as you referenced them, were schedules that were still hallucinogenic that should probably continue to be under Schedule 1, even though we took everything else out of Schedule 1.
Okay, so we took a fairly small bill and turned it into how many pages?
Mr. Chair?
50-some pages.
Mr. Chair?
Yeah, Senator Boyce.
Thank you. Mr. Chair, one of the things that we talked about, I think it was in Judiciary, but it might have been in rehab, I just wanted to make sure, is we were talking about the amount of THC in each of the gummies as opposed to weight, to make sure that it was in the actual milligram or whatever the actual.
Right. Mr. Chairman,
amount.
I can speak to that. We have the expert here, but that's included in the enactment clause, where it's 0.25 milligrams per serving for a certain size.
Okay, let's hear the speakers, okay? Coming up. Thank you for being here.
Yes, Linda Jackson, Director of the Department of Forensic Science. It is true that we have in this bill draft, the way it is, we've expanded the definition of marijuana to include THC, not just to include Delta-9 THC, but also to include the other isomers of THC as well, which are Delta-8, Delta-10, Delta-6A, 10A are the ones that are the most common. And DFS, for most marijuana samples that we would receive for analysis, they're going to have generally THC concentrations that are well above the 0.3% that is the limit for industrial hemp. And so those will be easily analyzed using the same methodology we already use. And we are currently, because this is before you, we are currently developing the method to expand it to include those other isomers that I just spoke of, so that we will be able to analyze most products except edibles at the moment for marijuana versus hemp.
Okay. You happy with the bill? Do you have any recommendations?
We have made recommendations.
That's in the substitute?
Right.
Okay. Okay, thank you so very
Thank
much.
you.
Next.
Mr. Chairman, sorry, I have a question for
Yeah,
Ms.
Senator
Jackson.
Sherrill.
So just, I think I heard you say a minute ago that you're capable of analyzing everything except edibles, right? And we're currently talking in this session about legalizing the sale of edibles. So how would we prosecute somebody who has an illegal edible if you can't process it?
So currently, we would probably, if we needed to analyze an edible for a criminal prosecution because it was through the illicit market or it was over a certain weight limit or for whatever, right now, if it needed to be done, we would look to outsource that. There are no other forensic laboratories that I know of in the country that are analyzing edibles at this point, including the DEA. So it's something that's being developed, and one of the issues is just with the different matrices, because you have to be able to not just analyze gummies, but also brownies and Rice Krispie treats and lollipops, and so it's a lot of different matrices to create the method for.
Mr. Chairman, for the question.
Yeah, Senator Sherrill.
And again, just so I'm clear, because the illegality of it is premised upon the percentage of THC, you could get the same amount of THC if you just make the lollipop really big to get the percentage down, right?
That is correct, and that is kind of the deal, like with the brownie, because the brownie just weighs a lot.
Right.
And that was the concern that was addressed by the additional language that was put into the enactment clause that capped a per serving dosage of 0.25 milligrams or 1 milligram for the entire package. And so it would preclude you from making a giant lollipop.
Okay. Next. Any other questions? Are you looking to make a giant lollipop or something? Go ahead.
Be one fun lollipop.
Yeah. Okay, come on up. Yeah. Next. Yeah.
Thank you, Mr. Chairman. Tom Atorcio with the Virginia Catholic Conference and Virginians Evaluating Drug Legislation. Thank you, members. We support this bill strongly. This is a very important issue for the Commonwealth of Virginia already, because in Roanoke, there have been instances where children have found Delta 8 in their candy. Roanoke, in fact, as recently as October, just about 2 weeks before Halloween, a 2-year-old by the name of Maya Sarir was poisoned by a package of Apple Jacks. It was branded as Apple Jacks. And she consumed this because they were at the pool, and there was some candy there at the pool, and the family brought back a bunch of candy from the pool, and included in that batch was this Applejack product. And so that, all of a sudden, Maya came back to her mother and said, "My face is burning." And she said that the small package of cereal had ended up in a basket of snacks. And then they, you know, of course, it was the ER was involved. She had hallucinations. It was a very, very dreadful experience for this 2-year-old girl. And this is something that's happening all across the country, and that's why states like Colorado and 19 states total, 19 states have prohibited Delta 8 and other isomers like Delta 10 and and related ones. So this is a very good bill. It's very timely. I have these articles right here from the Roanoke newspaper, and so with that, I'd also just like to mention that in Colorado there was actually a child who died, and this was documented in a UC Irvine medical journal, Clinical Practice in Cases in Emergency Medicine, and I have that information if any member would like to see that. So this is happening all across the country, and we really appreciate your consideration of this bill.
Yeah, we appreciate it. Okay, next person, thank you very much. We're short of time, so make it quick if you can.
Mr. Chairman and members of this distinct body, my name is Dylan Bishop. I'm here on behalf of the Cannabis Business Association of Virginia, here to express some concern with the bill. While we wholeheartedly and unequivocally supported the original 3-page bill submitted by Senator Hanger and the intention behind that, this substitute is substantially longer and has expanded significantly in scope. To address the gentleman who spoke before me, this bill does not ban or prohibit Delta 8 or Delta 10 or any of the other isomers, but it sets it amends the definition of marijuana, and I think it may have unintended consequences. I think that the representative from the Department of Forensic Sciences also raised an intelligent and cutting point here, is that this bill seeks to set limits on the THC content of these edible products, but we just found out that that's untestable by the Department of Forensic Science, so why are we setting those limits in the first place? So again, we're wholeheartedly in support of the patron's initial premise, the 3-page bill that was originally introduced. I appreciate Senator Hanger hearing our concerns continually, but think that this bill has gone beyond the bounds of its original intention, and would ask you to consider those concerns. Thank you.
Okay, anybody else want to speak? Okay, Senator Hanger.
Thank you, Mr. Chairman.
Somebody else wants to speak on Zoom.
Magister A. Beebe, would you please unmute?
Sure. Good evening, Mr. Chair, Senators. Nigas Tabebi. I am Vice President of Public Policy with Columbia Care, one of the licensed pharmaceutical processors in the medical cannabis program here in Virginia. I'm commenting today in support of this bill. I think that it wisely brings all forms of THC into a coherent and consistent definition so that it can be treated and regulated to protect consumer safety and to ensure that all consumers can be informed of what they're purchasing. And I will also just further clarify, it is very possible to test edibles for their chemical makeup, and I believe the Department of Forensic Sciences was speaking to field tests, which might be a different setting and more difficult for edibles, as the previous speaker mentioned, but we regularly test products in the medical cannabis program in a variety of formats to ensure accuracy in chemical composition and safety. And again, just thank you for considering this bill and ensuring a safe and regulated cannabis market in Virginia.
So you support the bill, right?
We support the bill.
Yeah, okay, I just want to be clear. All right, next.
Michelle Priola, would you please unmute?
Hi, I'm an impacted parent. My name is Michelle Priola, and I'm calling in from Colorado, where we've experienced the Pandora's box of legalized marijuana here on our youth. My son was impacted at age 14 and started dabbing, smoking, ingesting gummies, especially the things that looked cute and like candy. He went into psychotic states and this 5-year addiction. We needed to send him away to a recovery center and have spent over $60,000 to bring him back to health. He is now 19 years old, still struggling with an addiction. It's really stolen a lot of his free will and his ability to work.
Are you
and
in
his
favor of the
ability.
bill or are you against the bill?
I am in favor of the bill. I
Okay.
think as much regulation as possible.
Okay.
Mr. Chair, this
Appreciate
is a terribly complex
Yeah, thank
bill.
you. Thank you very much.
It has to go to finance. I would move that it has to go to finance if we report it. I move we report and re-refer to finance with the understanding that we're going to have to continue to work on this.
All right. Second. Yes, it's been moved and seconded that the substitute be reported and re-referred to finance where we'll work on it even further. All in favor of the motion, vote aye. All opposed, no.
Pass 14-0.
Okay. Senator Hanger, what else you got?
Thank you, Mr. Chairman. I appreciate your indulgence there with that. I think I have two bills now that I think can be fairly quick. Senate Bill 649, Mr. Chairman, involves juvenile law enforcement records, disclosures to school principals. Mr. Chairman, last year this committee supported this bill unanimously, as did the full Senate. And I think the events of this past year, which were highlighted in the media, would call attention to the fact that they shouldn't have sat on it in the House Judiciary Committee. It changes from discretionary to mandatory that the chief of police or sheriff in any city or county disclose to a school principal all instances where a juvenile at the principal's school has been charged with a violent juvenile felony, an arson offense, or concealed weapon offense. That's essentially, you saw it last year, you reported it favorably.
We liked it last year, right?
Right, that was last year, and
Is there anybody want to say anything one way or the other? Okay, been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no. Got another one we did last year?
Pass 14-0.
thank you, Mr. Chairman.
Okay.
The final bill that I have in front of your committee, and again, this can be simple. It's a concept that's based on a law in Georgia which was brought to me by a Commonwealth Attorney's Office in Augusta County, where they're looking for diversion programs where they can deal with individuals that are there in front of them that may have substance abuse problems that need rehab rather than being convicted, or mental health issues compounding that. It basically authorizes the attorney for the Commonwealth to create and administer a pretrial intervention and diversion program. And it takes into account the nature of the crime and various things which you can read in the bill. The Supreme Court recommended that we eliminate the last line of this bill, or last sentence of this bill, which would be beginning on line 28 and running through where it says any restitution collected under this subsection may be enforced and dispersed pursuant to the provisions of, and it cites a code section.
Senator Hanger, Mr. Chair.
Yeah, Senator
Just,
JT.
I was looking at section D, beginning on lines 24 to 27. I'm all for diversion, but you've made really no, in this bill, there's no place for people who are indigent. $300 might be a lot of money for some people.
I think there was someone here supporting the bill, if they haven't left, that wanted me to reduce that figure.
Okay.
And that's something that she may want to, she was in support of the bill, if you would want to hear from her now.
Yeah, go ahead.
Chairman Edwards, Senator Deeds, you hit the nail right on the head. I spoke to Senator Hanger about a concern about the $300 fee and there being no provision in the bill for any waiver for indigent clients or indigent persons.
Well, do you agree with me that the
I agree with you.
Commonwealth Attorney already has the ability to set up this kind of program?
I don't think there's any prohibition to it.
Okay, and the prosecutor's offices could do this if they wanted to, right now?
I'm actually familiar with PTI also because we had it in South Carolina when I first started practicing a while back. I think the way PTI works is you never even see a lawyer, you never even see a courtroom. It's a prosecutor administered diversion program. So in the limited experience I've had with it down in South Carolina, you never touched the courtroom. This was completely run by the prosecutor's office, and I lived in a college town, and it was frequently used for college students. Frequently used for college students. But that's my experience with PTI. But the concern I had, and that I brought to Senator Hanger's attention, is the $300 fee, because it would then become just something that only someone with $300 could avail themselves of.
So you'd like to delete lines 24 through 30, is that right?
Or provide that it would be waived for someone who's found to be indigent.
Right. Somebody who's eligible for court-appointed counsel, so.
Yes, sir.
Mr. Chairman?
Yeah, Senator McDougal.
But I understand that, but the way you get to be determined if you're eligible is to swear the oath in front of the judge that you're indigent. Use a list of factors that you have to go through. So that totally eliminates the entire process.
Senator McDougal, you're correct. What I have seen in other states is you can swear. You don't have to be in front of a judge to swear. And again, I'm not advancing it or discouraging it, but the finding of indigency in other states is not always found necessarily in front of a court. It could be found in a clerk's office. It could be through a sort of an administrative office where you just go to that office and you say, I want to apply for PTI.
The clerk's office.
Well, how about just deleting those lines 24 through 30? D and E.
I don't know that you want to, Mr. Chair, I don't know that you want to eliminate totally D, because I think you want to authorize the payment of a fee for those who can afford it. But what she's trying to set up is some kind of determination of indigency, and you can waive the fee in that circumstance.
The concern is that it would automatically preclude anyone who doesn't have $300.
Mr. Chairman?
Yeah, Senator McDougal.
I'm looking at the items to get into it, the nature of the crime. Typically through systems we use a similar system, diversion and juvenile system. But through that, there's some policy that's established of what types of offenses, and typically felonies are not diverted. So it would only be misdemeanors, and very rarely are misdemeanors that are acts of violence like assault diverted. So I understand what Senator Hanger is trying to do, but it seems pretty open-ended right now. And
well, let me ask you, why do you need it? Prosecutors can do this anyway, can't they? I don't know. Maybe it's a prohibition. I don't know what.
Mr. Chairman, I can't respond definitively to that, other than the Commonwealth Attorney's Office in Augusta County that is looking at all methods of diverting a diversion program, thought that this would be good, that it's been done in other states and provides a uniform system. It also includes anything that's subject to mandatory minimum is not eligible, but so I wouldn't be able to speak to expanding that.
Let me ask Steve Benjamin, can a prosecutor do this anyway, or is there any prohibition? Would this help?
I'm not certain that a prosecutor has the discretion to do what the patron envisions.
Okay, all right. Well, would somebody make a motion that you have to be indigent?
I would suggest this language, Mr. Chairman, on line 25, after the word program, inserting which fee shall be waived upon affirmation under oath of indigency.
Okay.
I'll make that motion.
Is there a second? All in favor of the motion, vote aye.
Aye.
Aye. All opposed, no.
And then you, Mr. Chair, the patron wanted to delete subsection E, on lines 28 through 30.
Right, at the end, actually leave the first part, first sentence, but beginning with any restitution, strike all of that. That's what the Supreme Court had asked for.
Okay, I'll make that motion.
Okay. Any restitution collected under the subsection will be enforced and dispersed pursuant to section blank, 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 okay? That, is there a motion? The motion been made, is there a second?
Second.
To delete that line,
I moved it in second.
that one sentence. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. All right, is there anybody want to speak in favor of the bill or against the bill?
Mr. Chairman, we do have
Okay.
people online.
Okay, good. Gary Hughes?
Good afternoon, Mr. Chairman, members of the committee. My name is Gary Hughes. I'm the president of the Virginia Community Criminal Justice Association. So we're comprised of pretrial local probation officers throughout the Commonwealth. So we support the concept of pretrial diversion as part of an ideal pretrial system. We did have concerns about it being equitable for all and about financial access being a concern. So if those are addressed, we certainly support the concept. We want it to be equitable and we want access for all with the system. And I think one of our other concerns would be as talk of diversion continues, and I know there have been some studies both from the Crime Commission and others on the idea of diversion. If this is to be implemented more widely, we do think a consistent process and application for diversion throughout the Commonwealth would be helpful.
Okay,
Thank you for your time.
Thank you very much. Another speaker?
Dominic Martin, would you please unmute?
Good evening, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority. I'm definitely in support of the concept of pretrial diversion. Anything to, divert people away from the criminal legal system is a bonus. I think I would actually echo the sentiments of the speakers before me with the concerns. I think we, as Mr. Hughes kind of just pointed out, we'd like it to kind of be uniform across the state. We already spoke to the $300 fee and the access portion of it. And then I would just finally add that the mandatory minimum portion of it, we would not like that included because it kind of gets to the point of, what the issue with mandatory minimums are, and that it takes away the discretion to use your best judgment in certain cases like this, and that kind of just defeats the entire purpose. And so we just have those concerns, not really necessarily support or against, just those concerns, but generally support the concept. Thank you.
Thank you. Anybody else want to speak, one way or the other? Are we ready on the bill? Senator Anger, you ready for, anybody want to make a motion that we report the bill? The motion's been made and seconded that the bill, as amended, be reported. Senate Bill 674. All in favor of the motion, vote aye. All opposed, no.
Ayes 13, noes 1.
13 to 1, the bill is reported.
Thank you, Mr. Chairman, members of the committee.
Finished? Okay, thank you very much. Senator Eben here? Okay,
Yes.
Senator Eben?
Thank you, Mr.
You have
Chairman.
a real property issue.
Yeah, this is SB 311 about declaration of interest relating to real property, duty to disclose ownership interest and lease pendants. There's an amendment in the nature of substitute, which has narrowed the scope of the bill a bit. It removes the language that referred to title insurance, but it maintains the language requiring to disclosure of interest in the property and any pending legal action against the property.
Okay. Anybody, motion to adopt the substitute? Is there a motion? Second, moved and seconded to adopt the substitute to Senate Bill 311. All in favor of the motion say aye. Aye. All opposed, no. Motion carries. Okay, Senator Evans.
Thank you. The first part of the bill would codify a duty for a real estate licensee to disclose to other parties in the transaction any ownership interest that the licensee, any member of his family, his firm, or any other entity in which he has an ownership interest may have or will have in a property where the licensee is also a party to the transaction. The disclosure of the ownership interest would have to be made by the licensee upon having substantive discussions about specific property. The second part of the bill would require an owner who has actual knowledge of a lease pendants, a lawsuit over the ultimate ownership of the property, filed against his property to disclose that fact in writing to a prospective purchaser. This came from a situation in my district where someone was moving into South Arlington, purchasing a property, which is a momentous investment, of course, and a realtor is assumed and meant to be an impartial broker in this process. But the buyer should know if the realtor has a potential conflict of interest during the process, as they may affect how they evaluate the property. Additionally, people wishing to invest in a property ought to be notified if there's pending legal action against the property. In this case, my constituent had invested substantial funds in home inspections and all deposits, appraisals, inspections, and they didn't discover until very late in the process that there was a lease pending in this particular situation. And we worked with the realtors. They've been really helpful over the summer in developing this language and in the substitute that's before you.
Mr. Chair.
Senator Peterson.
Is somebody here from the Realtors?
Yes.
Hi.
Hi, Mr. Chair, Committee, Erin Barton with the Realtors.
Hi, Erin. I file a fair amount of lis pendens. Normally, in every real estate transaction, they're going to do a title bring down, and a lis pendant is going to pop up on that, correct?
That is correct. However, the title search is often not done until much later in the process after the prospective buyer purchaser has put out sometimes significant funds for inspection, surveys, appraisals, et cetera.
Okay. All right.
This would require the seller, if they have actual knowledge, to disclose it up front, and then the purchaser could decide whether they wanted to go forward and put down that money or
Okay,
not.
and that certainly makes sense. I guess this next question would be, if they don't, what's the remedy? I mean, you can't.
If they
put a
don't
sale.
disclose it,
Right, I mean, what do you do?
the remedy is for the buyer to be able to get out of the contract.
And get his deposit back?
Does it say that?
I think you need a remedy in here, because
Is this the law?
it just says you can't do it, but then it doesn't say what the penalty is.
I don't have the actual full statute here. I think the remedy is in the full
think that is the
chapter.
full
Say that the contract's voidable or something like that based on lack of not being revealed. And also, how do you know that it's been just an accident?
In the circumstance
I mean, I agree with you,
that we
but-
had, it was pretty clear.
Well, yeah, Adam, this is a good idea, trust me.
Yeah,
I think
no,
it's
I'm
more
all
a
for
question of what's
penalty.
the remedy if they don't comply with this statute.
Mr. Chairman, the statute is being added to Chapter 7 of Title 55.1. There's another statute in that chapter that has actions, it's titled Actions Under this Chapter, and it provides for the remedies.
Yeah, what's the remedy?
Well,
Who knew?
A bunch of,
Yeah, what are they?
the
Like
contract may be
minimum
terminated.
mandatory?
yeah, it's 50 years.
No, it says the contract may be terminated,
Mr.
and he can recover actual damages suffered as a result of the violation.
Mr. Chairman,
All right, yeah, Senator Sherrill.
so I don't see a problem with the intent, but the way I read it, it's not clear to me when the disclosure has to be made. So, you know, the contract gets signed and often there's 30, 60, 90 plus days before the closing happens. And it's not clear to me that if the list pendants drops, 30 days after the contract's signed, but,
You're talking about the list pendants disclosure?
if a list pendants drops, if somebody gets served, when you file a list pendants, you have to usually file a lawsuit at the same time and you get served with both.
Right.
Well, actually, I'm not sure you're actually required to be served, but you file the complaint with the list pendants and you can just hold it back and not give it to them. But in any event,
Don't you have
assuming,
6 months to file the complaint after?
No, you're thinking of mechanics lien deeds. No, you
Yeah.
serve a list pendants with a lawsuit.
right, but you don't have to serve it until you're ready to serve it.
Right,
There's
you
no
don't.
so.
You don't have to file list pendants.
Right, but in any event, my point is that the contract could get signed, 30 days could go, then they could get the list pendants after the contract's signed, but before the closing. And it's not clear to me that this disclosure is required during the pendency of the contract period, the way this is written. It just says somebody has a duty to provide it and doesn't say whether it has to be right at the very beginning or whether facts change while the transaction's pending. They have to make it at some point during the pendency or the day before closing, if they find out the day before closing. So there's some ambiguity there.
Mr. Chairman, there's another section in the same chapter that would apply here. It's 55.1-7 or 9. It says, the owner of a residential real property subject to this chapter shall provide notification to the purchaser of any disclosures required by this chapter, which this would be, prior to the ratification of a real estate purchase contract. So that would be the timing that would apply in this case.
It says here,
Mr. Chairman, I'd say
disclosure-
Ms. Walsh is pretty smart.
the disclosure shall be made upon having substantive discussions about specific real property. What does that mean? Substantive discussions?
That's for the conflict of interest disclosure, and that is a defined term in the real estate world, that when you're having an actual discussion with a client about a specific property and they're asking a question or information that would take your professional judgment, that's a substantive discussion.
And Mr. Chair,
Senator
the
Dees.
first part of the bill just puts in the code something that's already the Realtor's responsibility, right?
It's already in the regulations.
Right.
Yes.
Right.
I believe the language was taken right from the regs.
I actually have a case right on this. I like this bill.
All right, Senator
I wish I could be a
Peterson.
co-patron.
Senator Peterson.
I would like to arrange for Senator Peterson to be a co-patron. It'd be
Okay,
an honor to have
I'll
you.
move to report. Unless you-
All right, any further discussion? All right, all in favor, it's been moved. Is there a second to report the substitute Senate Bill 311? All in favor of the motion, vote aye. All opposed, no.
Ayes 14, no zero.
Okay.
I like this committee better than general laws. I didn't do as well over there. Thank you.
Mr. Chair,
Yeah, Senator Peterson.
if you don't have any non-committee, can I take up two bills? Or, yeah, one will be.
The only bills we have left from members of the committee.
Okay, I'm supposed to have dinner with the Secretary of Agriculture of South Korea tonight, so. Yeah, can I get, they'll be quick.
We can take up bills and we can save them till Monday.
Okay, can I, Senate Bill 206, can we save that to Monday? If I so move?
Yes, 206, yeah, Monday,
Monday.
and 715.
715, Mr. Chair, members of the committee, this was the bill on Supreme Court appeals of injunctions. And do we have the amendment? The sub?
The motion to pass it by indefinitely?
No.
Not yet, okay, not until we look at it at least.
And let me just, as way of background, this is section 8.01-626, which is how you appeal a preliminary injunction. And a preliminary injunction, you get it after a very finite period of time. You have a brief hearing. It's temporary by definition. And so any appeals of that, and these often are First Amendment cases or other type of sort of high-interest cases, it goes directly to the Supreme Court. So you don't have any intermediate appellate court. And the reason is because you don't want to waste time. You want to get a ruling right away. I mean, we have this rate going on right now with Governor Youngkin's orders. And so my point was, when we had that situation in place, we had a procedure in place, which I had helped write this bill about 5 years ago. We then sort of undid it when we redid all the Court of Appeals legislation. I was asleep on the deck, okay? It's on me. I thought I amended to remove it. Apparently I had not. This keeps the law as it was as of December 31, 2021.
Mr. Chair.
Yeah.
I want to understand, I don't do much appellate work.
Sure.
Since I put in that bill a number of years ago to abolish the Court of Appeals, I kind of stay away from appellate work. But let me ask you this,
Yeah.
Mr. Peterson, if
Yeah.
you've got a substantive appeal that goes to the Court of Appeals, but a preliminary injunction that goes to the Supreme Court, and the
Right.
Supreme Court grants they stay your appeal, or they stay your injunction, doesn't that prejudice your appeal in the Court of Appeals?
No. The injunction would be, well, before the case had been decided on the merits. This is a preliminary injunction.
Senator
Well,
Peterson.
but it says preliminary permanent.
Senator Peterson, can't you ask for an expedited appeal? We have a Court of Appeals.
It says
And-
preliminary permanent.
Well, you could strike permanent. It meant to be just preliminary injunctions. The bottom line is, if you have a preliminary injunction, let's talk about the case that's going on right now. Let's say Arlington County Circuit Court judge issues an injunction. Let's say they want to get an immediate ruling on it on the merits. Why not just have them go right to the Virginia Supreme Court? Why do they have to go to the Court of Appeals and then appeal again and get to the Supreme Court? We need finality in these situations.
But Senator Peterson, can't you ask for an expedited appeal to the Court of Appeals and then an expedited appeal to the Supreme Court?
You know what? You can, but it's a waste of time. Look, the statute as we had it before was perfect. We mucked it up for no reason.
Mr. Chairman,
Take one right.
Yeah, Senator Serval.
I have a question for the patron. So I noticed that you've also added, you've eliminated the Court of Appeals pit stop on lines 13 and 14 for orders reviewable under 801-675.5, which are when a circuit court tosses you out based on sovereign immunity, absolute immunity, qualified immunity, or charitable immunity. Is that right?
Well, you know what? I think this was just as the law, as the statute was on on injunctions. I don't care about anything except preliminary injunctions. You want to strike out everything else, I'm fine with it. But the preliminary injunction piece is important because, again, you need to get these heard as soon as possible.
Mr. Chairman, to get this in a proper posture, I would move that we strike or permanent on line 12 and take Romanet 4 out on lines 13 and 14 to get it at least in a form that.
Well, Mr. Chair, doesn't that require that the whole section be rewritten? Because you've got to have some provision for an appeal of a permanent injunction too. You've got,
No, that would just fall under the current statute.
Well, Senator Peterson, you can do an expedited appeal already. And
I know.
Okay,
You made the point
that's
4
final
times,
unless
Mr.
somebody overturns it. Yeah.
Mr. Chairman, I move we adopt the substitute.
Second. Mr. Chair.
Yes,
I
Kirsten.
have it in concept, but it's just going to look a little different now if we strike permanent because we're going to have to put some stuff back in that we had taken out. So just with that understanding, okay.
All right. All right, you know, well, fine, I'll take it to Monday. I didn't mean to hold up your time. I thought it was easier than it was.
I
That's all.
don't, this
Okay.
is, it's a bad bill, okay. Yeah, we'll take it up on Monday.
Shouldn't be
Okay,
this hard.
good. Want to do mine? Well, there are already some people there. Yeah, no, well, on mine, I think there's people on it.
Oh,
You've got people. If you leave the building, you can't vote. Senator Edwards wants to take up a bill that I've got, 302. It's a substitute.
There's a substitute for the bill.
And Senator Edwards will explain the bill and explain the substitute.
All right, this bill originally started out as a guardian bill, natural guardians, and there's a substitute that we worked out that has to do with, it changed it from 50, where it was, 54.1 to, no, it was, where it started out as something, but it's now been rewritten. It used to be, what, the Senate Bill 302 is what it is. And this passes out as a substitute. What the,
So do I hear a motion to adopt the substitute? Is there all in favor of adopting the substitute, say aye. Opposed? Okay, the substitute, the fourth committee, Senator Edwards, and then Senator Voiska.
okay, basically it does the following. It puts it under 64.2-2001 F. It's a new F, and it says, no order of appointment of a guardian is required to obtain health care for an adult who is determined to be incapable of making an informed decision as defined in 54.1-2982, provided that the person authorizing the health care provider to provide, continue, withhold, or withdraw health care is a relative listed in Section A of 54.1-2986, and the health care provider has complied with the provisions of 54.1-2986. And then it goes on to say, any person, in the next section, 64.2-2002, any person, including a community services board and other local or state governmental agency, may file a petition for the appointment of a guardian or conservator or both. The first section that I mentioned, which is new, F, under 64.2-2001 restates what is already in 54.1-2982, which is really for the Healthcare Decisions Act. And it's there because not many people knew it was there. And it restates that a doctor can, if you don't have an advance directive or healthcare power of attorney or anything like that, then you have a doctor can, in order to do health care for a person that's incapable of making an informed decision, can get permission from relatives that are listed in Section A of 54.1-2986. They're listed in order. And then, so long as the healthcare provider complies with those provisions. And so that's basically restating the law, but putting it in a place where people can understand it. And the second thing is any person, including a community services board or other local or state governmental agency, may file a petition for appointment of a guardian, conservator, or both. And it further has an enactment clause, asking JLARC to convene a work group to consider the issues concerning the care of adults with permanent disabilities, et cetera. And that would be a work over the next year, and submit a report on November the 1st, 2002.
So, Mr. Chair, as I understand it, the bill does three things. Number one, if you meet the requirements under the existing law of not being able to make decisions for yourself, the people that are already outlined in another section of the code to make decisions, which would basically be your next of kin, would be able to make those decisions for you, number one. Number two, the community service board or any branch of government who doesn't agree with that can come in and it can intervene and file a petition for custody. And the third thing you do is over on page 3 or page 4, you set up a work group to be administered by JLARC to figure out a better plan going forward.
Correct. The community, and the reason, yeah.
Your point is that ARC should be capital A, capital R, capital C.
It should be capital T for thee, and then capital A and little r and little c.
The ARC of Virginia. Okay.
On line 89.
On line 89. Okay. Do I have?
That's correct.
That amendment?
That's correct. The Community Services Board specifically mentioned.
Okay. Well, so we've got a motion. Do I have a second for that amendment?
Yes.
Senator, all in favor of that amendment, say aye.
Aye.
Okay. So that's what the bill does. There are people, I think you said there were people online.
There may be, I don't know.
Anybody that wants to speak in favor of this bill?
For those attendees in the Zoom who would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we do have one person.
Okay. Ms. McCullough, please keep it very brief, under 30 seconds if you can.
Amy McCullough, please unmute and begin your testimony. You do have 30 seconds.
Okay, first of all, I'm Amy McCullough. I am one of the co-chairs of the Public Policy Committee for VELA. I'm actually not speaking in favor of the bill. VELA cannot support the bill. We do appreciate Senator Edwards taking the time to speak with us and work with us on this bill, but in its current form, we still believe that the language at paragraph F in 2001 still introduces some ambiguities into the code that weren't there previously. That language does refer to 54.12986, but it's not simply a statement of the law. It mentions the law in part, but not in whole. And so what's happening is we're shoehorning in some language from the Healthcare Decisions Act, which is aimed at medical providers, into the guardianship code. And there is also, you should be aware, a 54.1, 2986.1 and 2986.2 that are not referenced here. And because of that.
Ms. McCullough, do you think you could write this paragraph a little bit better to reference the law exactly as you think it ought to be referenced?
Honestly, this is something that to rewrite, we were hoping this could be passed by for the year, particularly if there's to be a JLARC study. And I believe the Disability Law Center had asked for the same to occur, though I'm not sure if they're there in the room.
I'm sure they are. Okay, 30 seconds, please.
Thank you, Mr. Chair. I'm Colleen Miller from the Disability Law Center, and thank you to your staff and Senator Edwards for talking to us about this. This is a pretty dramatic rewrite from what we had been working on with your staff. It It is very close to the Healthcare Decision-Making Act. I think it is actually in conflict with what we have in the Healthcare Decision-Making Act, because at 54.12986, it says that a healthcare provider may take direction from the list of family members in that hierarchy. And this suggests that the healthcare provider has to take the direction from that person. So I think it does put our code in some conflict. I also think it's not necessary because our Healthcare Decision-Making Act is really strong on this point. With respect to the work group at the end, you all know that JLARC has just completed a comprehensive study of guardianship, and we have not yet had a chance to consider all of those recommendations. I would suggest that if you would like for a study like this to happen, the Supreme Court has a group that they call the Working Interdisciplinary Network of Guardianship Stakeholders, and I think that they would be a much better position.
I'll tell you what, I'd like this bill to go back to Monday and for you to get with Senator Edwards and see if there's any accommodation could be made.
Okay, thank you.
I doubt it.
You know, if you're standing between us and something. So if you want to do that, then.
All right. This is Senate Bill 493. We've heard multiple times. Senator Peterson wanted an amendment, the substitute adoption amendment. I move the substitute.
So what was the bill number?
493, the unsolicited lewd pics. Yes. And can we vote on the substitute? Okay.
We've adopted the substitute.
No, I'm waiting for you to adopt.
Okay, all in favor of the substitute, say aye.
And
Any opposed? Okay, the substitute's before you, and the substitute now makes this a civil action, not a criminal action.
it already was. The only change is that it put trespass instead of conversion, and we report the bill.
Okay, the issue the last time, this came up last week, and the issue was that it wasn't whether it was a trespass or a conversion. Okay, we've got a motion to report and a second. Any further discussion? All in favor, vote aye.
Yeah, absolutely no.
Probably so.
Ayes 12, noes 1.
Another bill, Senator McClellan. Okay, well, it looks like Monday we would have one, Servo has two bills. With 9 bills. Do you think if we come in at 9 o'clock, we could do them between 9 and 11?
Oh.
9 bills. A session, do we know what time, Madam President Pro Tem, do we know what time session's gonna be on Monday?
No.
Jennifer, the reason I don't like that bill is not because of this.
Well, then we better stick to 8:30.
Absolutely warranted.
8 o'clock?
Situation where I can see.
8 o'clock?
8:30.
8:30, all right, 8:30 Monday morning.
And we've got 9 bills we've got to get rid of Monday. We'll rise.
Okay. Meeting's adjourned.